The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having any manner or form of business before the Honorable, the United States Court of Appeals, are reminded to draw now and give their attention. For the court is now sitting. God save the United States and this honorable court.
Mr. Birch, whenever you're ready, we'd be pleased to hear from you.
Thank you. Good morning, Your Honors. John Birch on behalf of Robert Kerr. I have reserved 5 minutes for rebuttal. It please the court. With full appreciation for the challenge we face in asking this panel to change its mind from the preliminary injunction appeal, I will press 2 points this morning. First, the law of the case does not prevent this panel from correcting a mistake in its earlier decision. And second, as the en banc Fifth Circuit explained in Kaufman, the previous opinion here is demonstrably incorrect. 42 U.S.C. 1396 AA23A does not create a private right, and Planned Parenthood is using its client to forum shop. I'll begin with the law of the case. The law of the case applies when the same panel decides a later appeal in the same case, whereas the law of the circuit applies when a different panel decides a later appeal in a different case. So we're squarely in law of the case land here. The law of the case does not constrain this court's authority. It's a discretionary rule intended to promote judicial efficiency. And as this court made clear in the Sedgman decision, a judicially created procedural doctrine cannot defeat the intent of Congress. And as the Fifth Circuit made clear in Hopwood, nor can a judicially created doctrine defeat a binding U.S. Supreme Court.
Let me understand where you're going with this. You're saying what we did in the previous case, this panel, we were just manifestly wrong. We ought to reverse ourselves and do it correctly. That's basically what you're asking us to do. You did ask the Supreme Court for a cert on that issue, and it seems like the Supreme Court didn't see it was so wrong enough to grant the cert on it. That doesn't necessarily decide it one way or the other. But I don't think I've seen a case like this in which a panel has published an opinion. And it's one thing to not publish opinion with the law of the case, but a published opinion has become precedent for the other panels. So essentially you're saying everybody else has been bound by it except this panel. Is that right?
Well, yes, that is right. And Judge Wynn, let me first address your point about the Supreme Court.
Let me make sure, let's work that a little bit, where you're going with that. Every other judge on this court, other than this panel, if a panel's formed, or if we were another panel that's not constituted as it is bound by what we did and has been bound, except this special panel that is now hearing something we published. I don't follow that. I'm trying to understand how that works, because if that's true, then anytime this panel is constituted, if that issue were to be brought back to this panel, even though it's not the same case, this panel could overrule itself. And I don't think that's the way it works. We don't write opinions for our panel. We write it for the court. So I just don't, has this been done before?
Well, Judge Wynn, our position is not that if this panel would write a decision in one case, it would not bind this same panel in a different case. Our position is that the law of the case applies.
The problem, Mr. Birch, is that our previous decision was handed down as a matter of law. And as a matter of law, whether it's a law of the case or the law of the circuit, we don't even have to get into whether it's the law of the case, because it's circuit precedent. And we don't have the authority to overrule circuit precedent. It's a binding opinion which was written as a matter of law. And you say, well, something's changed. And then what you have said has changed is a decision from the Fifth Circuit. Well, you're entitled to agree with the decision of the Fifth Circuit, but as I understand circuit precedent, if every time another circuit comes to a decision at odds with this circuit, we are obliged to change our own precedent and follow the other circuit that disagrees with us? What in the world does that do to the circuit precedent of this circuit? if any other circuit can overrule this circuit's precedent, which is what you're urging.
Well, our position is a little more.
That was the changed circumstance when we wanted to know what was different from this case and the prior case.
Judge Wilkinson.
Well, there's the Fifth Circuit in bank decision, but that can't be the way circuit precedent works.
Judge Wilkinson, our position is a little more nuanced than that. And to be
no, really, it isn't.
Your Honor, first, there's a difference between circuit precedent and law of the case. Law of the case applies when you have the same panel in a later appeal of the same case. And Planned Parenthood concedes this on page 20, footnote 5 of their brief. They agree that this court has applied a holding from an earlier appeal in the same case. It cites the law of the case doctrine, not the law of the circuit doctrine. And the reason why the Fifth Circuit's decision in Kaufman is so important is not just because it said this court was demonstrably wrong or erroneous, but because it undercut the reasoning that this court used to distinguish the binding O'Bannon case. O'Bannon is on all fours.
You're just trying to re-argue what you argued the last time.
Your Honor, 11-5, the Fifth Circuit en banc said that the reasoning in the previous opinion with respect to Kaufman was demonstrably erroneous. And let me just briefly comment on that.
I don't care what they said. We have a circuit precedent that is binding as a matter of law. You had a chance to take it up to the Supreme Court. They denied certiorari. And your view of circuit precedent is that we are obliged to change our precedent anytime another court says our precedent is incorrect, which happens rather frequently, by the way, not just with our circuit, but with all circuits.
Judge Wilkinson?
And you do understand that we as the Fourth Circuit, we can write such an opinion too about the Fifth Circuit. There's no difference there. We can say they are demonstrably wrong. The one that decides that will be the Supreme Court. They've already denied its certainness. They may grant cert, because it's split or down the road. But at this point, if you want relief, I would think you've got to seek some type of en banc relief. You can't come back to the same panel. Generally, when you're dealing with a law of the case, we're talking about the law that was made in a particular case. And then when this issue is decided, that same panel follows it as the law of the case, unless it's overruled by a sitting en banc case or by the Supreme Court. It doesn't work the other way around. You can flip back and forth as though you're in reconsideration in the district court. There's precedent here on this level. So I don't know, maybe you want to continue to press this, but I think your remedy, if you want to seek beyond here, is outside this panel.
Well, and if this panel thinks that the first opinion is correct, then that's exactly what you should do. You should issue the same opinion, and we do have the right to take it to the Supreme Court. A point that I want to make about the previous trip to the Supreme Court.
You have a right to ask the Supreme Court to consider it, which you did before.
But can I explain?
Maybe you might be more successful this time around on it, but at this point, what I'm saying is the argument you're making now may be simply to preserve it or to have it there, but I think that ship sailed, before this panel and now before the court. Precedent, we don't. I just don't know of a case where the same panel comes back, everybody else. What offends me the most about it, at least my notions of what ought to be right, I can't believe my colleagues are going to be bound by something I'm not. I think if it's precedent, it just binds everyone.
All right, Judge Wynn and Judge Wilkinson, you both brought up the Supreme Court cert denial, and so I'd like a chance to address that, and then I'll go back to law of the case.
I don't know why that's necessary, because that's, we're talking about it. The Supreme Court can do whatever it wants to do at this point. That's not what's before us, but I mean, you can articulate it, but it still doesn't get you into relief before this panel. It might get you a chance to talk a little bit about what the policy and everything else, but you are here to try to get some relief before this panel. And I think that's where you should focus your consideration.
Very briefly, when we filed the cert petition the first time, it was from the preliminary injunction appeal. The district court then entered a final judgment, which rendered the interlocutory preliminary injunction appeal moot. That's the reasoning that Planned Parenthood articulated to the Supreme Court as to why it should deny cert, and that's presumably the reason why I accepted it. So the Supreme Court denial of cert doesn't have any bearing.
Excuse me, Counselor, Judge Richardson had a question.
So I have I think a sort of more sort of basic question, perhaps. So I assume that I agree with you that law of the case applies.
Yes.
And we can talk about what law of the case means and whether there's an exception that applies here or not. The question that I've got, and I accept that, but why, can you help me understand why law of the circuit does not also apply, right? So why is it that because we fall within law of the case, that is an exception or an inapplicability of the law of the circuit, right? Why wouldn't we say that both apply just as a matter of law? I'm not talking about what's a good idea or anything else, but when you look at our law of the circuit, why does the application of the law of the case mean that law of the circuit is no longer applicable?
Because this court has made clear that the law of the circuit applies when you have a different panel in a different case. And there's practical reasons for that. We don't want.
All right, so tell me, in what case have we made clear that the law of the circuit is limited to different panel, different case?
LJ versus Wilbin and U.S. Department of House and Urban Development versus Cost Control Marketing and Sales Management. Those are both cited on page 10 of our reply brief. They're also referenced on page 20, footnote 5 of Planned Parenthood's brief. And there's a practical reason for that, Judge Richardson, in that if you have a different panel in a different case, we don't want them calling balls and strikes, saying that a previous decision was erroneous without going to the en banc court. Another panel cannot overrule a first panel. But when you're talking about the same panel in the same case, the law of the circuit is inapplicable because this panel is in the position to fix it.
Excuse me, Judge Wilkins, go ahead.
If I can just follow, I want to make sure I understand the framework. And is your view that applies whether the law of the case is a factual determination type, or mixed question at a preliminary injunction stage, or a legal question at the preliminary injunction stage, that whichever that is, it matters not. We only apply law of the case when we're back on a permanent injunction appeal.
Correct. The law of the case would apply to the facts or the law. If there was a change in facts, obviously that's a strong reason to reconsider and then change a mistake in a previous opinion. But this court is clear too that if it makes a mistake, it has the ability to correct that mistake. And there are three contexts where that's true. In Sedgman, it said if the previous opinion is contrary to what Congress intended, and that's under law of the case. Second, Hopwood, the Fifth Circuit decision says when this court.
I don't think you're responding to Judge Richardson's point, and that is, even if law of the case doesn't apply, why does that affect what the law of the circuit is? And the previous opinion was rendered with respect to a question of law. And the question of law has not changed. It's the same that it was. And so it really is circuit precedent. And yet your view is that circuit precedent may be controlling, except it's not controlling in cases where the circuit precedent was rendered. And maybe that's, the forces behind precedent and circuit precedent are to afford a degree of stability to circuit law upon which litigants may rely. And that rationale holds true whether it's the same panel or a different panel. Litigants need clear signals, and following precedent lends the law stability and sends litigants that clear signal. And what you're proposing is highly is destabilizing, which is that everything is sort of up for grabs by some ingeniously contrived exception. And I don't see what I don't see that this case differs in any material respect from the previous opinion, and except that another circuit has disagreed with us, fine, that's their prerogative. But our prerogative is to follow, and more than our prerogative, it's our duty to follow our own case law and our own precedent.
Judge Wilkinson, when we're talking about law of the case, we're talking about the narrow situation.
And we don't need to get into the case. It may or may not be, and we can have an angel dance on the head of the pin debate over that. But the point is that there is a circuit case out there which is binding precedent, and litigants are entitled to rely upon that. If there had been a change of any kind of change of circumstance, that's one thing. The only thing that you've pointed to is the Fifth Circuit. And you find a point to the Fifth Circuit, and when you take a certiorari petition and you can point to a circuit split, and fine, the Supreme Court will decide that. But we don't have the authority to simply toss it overboard.
Judge Wilkinson, I see I'm out of time, but can I briefly respond to that?
Yes, you may.
This isn't my rule. This is the Fourth Circuit's rule. In Capital Investors, this court said, courts have inherent power to correct earlier error if it becomes apparent. In American Canoe, this court said, this court's responsibility is to get the law right, even if it was wrongly stated before. In Sedgman, this court said that if we issue an opinion that's contrary to congressional intent, a subsequent panel can fix that error. All I'm saying is, if there's an error, this panel has the power.
Let me ask you this question. Do you think this panel doesn't know what circuit law is here in terms of how we handle cases? I mean, you have 3 judges here, and we've articulated to you what it is. And you're telling us what it is in our circuit. It is very clear, and it's been set in an en banc case, that if you have a published opinion, that's what Judge Richardson is referring to, circuit precedent. If it's circuit precedent, then it's precedent. And if it's in direct conflict with any issue, the earliest opinion controls on that. That's the precedent here. And you are telling us what this circuit's law is. This is the most incredible argument I think I've heard in a long time. You keep telling Judge Wilkinson what the law is in this circuit. And I know Judge Wilkinson has been on this court for over 30 years. I've been here for a bit, and I'm trying to figure out where are you getting this from? And you keep saying the same thing over and over again, and you're not listening to what is being said. So I think it's very clear. I mean, if you want relief, I'm not saying you can't get it. I don't think you can get it to this panel. We have en banc, you have the Supreme Court, there are other avenues. The Fifth Circuit is not the way to go. There are other circuits too. They can use as strong a language as they want and in terms of how they feel about our opinions, but nonetheless, we can too. We just won't, because we tend to be a much more courteous circuit, I think, admitted than others in terms of doing that. We're just not going to do that. But that's just the way it is. Precedent is precedent.
Judge Wynn, I'm not trying to tell this honorable panel, this distinguished panel, what the law of the Fourth Circuit is. All I'm saying is what you just discussed in that en banc opinion is circuit precedent. It's not law of the case. LG versus Wilbin and U.S. Department of Housing and Urban Development.
It makes no difference. If it's circuit precedent, it's circuit precedent. And you've just essentially conceded the point. But trying to get out of the law of the case, you've put yourself in the bucket of circuit precedent. At any rate, sir, you've got 5 minutes for rebuttal, and we'll be happy to hear from you in rebuttal. And in the meantime, we'd like to hear from Ms. Saharsky.
Thank you, Judge Wilkinson.
Good morning, Your Honors. I'm Nicole Saharsky. I represent the appellees. I think the bottom line here is that the state is trying to relitigate a statutory interpretation question that this court already decided. It's binding circuit precedent, law of the case, and it's persuasive and well-reasoned. There's not any reason to revisit it here. And I guess I'd just like to address a couple of points that have come up so far in the court's questions. First of all, Judge Wynn's question, is there any other case like this where there was a binding circuit precedent and then a panel revisited it? I think the answer is no. If you look at the cases that are cited in the briefs, there's not another case like this. We found 4 cases, one unpublished in the Fourth Circuit, where the court actually came back and said it wasn't bound by law of the case. And in those cases, something had changed. There was either they didn't decide the issue, there were new facts, something like that, and perhaps there wasn't a published decision the first time around. So it really would be unprecedented what the state is asking for here. And the Sedgman decision.
Counsel, can I follow up on that? I mean, so I want to go back to this idea and law of the case, and there are exceptions that exist there. But when we fall within law of the case, I maybe don't find it as unbelievable as some that the law of the circuit might not apply. And in part because I go back and I read the en banc decision that my colleague referred to earlier, and it talks about the law of the circuit means that the panel's decision is binding on a subsequent panel. And I read that to suggest the subsequent panel means like not in the same case, right? For the same reason that we could grant panel rehearing, that as long as we're in the same case, that the law of the circuit doesn't bind us. And sort of there are these cases that find that law of the case doesn't apply, which would mean that they've also at least implicitly found that law of the circuit doesn't apply. And so I'm having a little bit of trouble understanding what's the real rationale for applying law of the circuit when we have law of the case. And this is maybe a totally academic question because, I think you can hypothesize here that you're going to win either way on this issue. The only rub is which is the right doctrine to think about.
Right. So in terms of this court's precedent, there are multiple cases where this court has applied both circuit precedent and law of the case in circumstances like this one. And I would point the court to those cases because I don't think that there's any case to the contrary anywhere in the state's filings. The Tatum case, which is an ERISA case about an ERISA legal issue, is one of them. There's the Columbus America case, which is about an abandoned shipwreck.
Tatum, all right, so I get Tatum, but I'm not sure that it's like that's just dicta there, I think. But okay, what's the next one? Give me the next one. I'm not sure that I know.
Well, respectfully, I don't think Tatum is dicta. It goes through both law of the case and law of the circuit. And I suppose you're right that the court could have rested on either ground because either one of them would be dispositive, as we think either one would be dispositive here. But the court did opine on both of them. There's also the Columbus America case, which is about an abandoned shipwreck. There's also the Housing and Urban Development, U.S. Housing and Urban Development case, which was a case on preliminary injunction that addressed whether some defendants were developers within the meaning of a certain federal law that required disclosures. That issue was decided on preliminary injunction. And then when the case went back to the court said it's binding circuit precedent and law of the case. And the only case that the state cites for the proposition that circuit precedent would not apply is a decision from the DC Circuit in a case called LaShawn A. versus Berry. And in that case, too, the court suggests that both law of the circuit and law of the case applies, although frankly, it says it doesn't really need to get into the interplay between the two because the law of the case doctrine would be dispositive. So I just don't think that there's any precedent for what the state is suggesting here. I agree with you that it's an interesting question. I think the better view on that question is that circuit precedent does apply because of the stability and predictability interests that Judge Wilkinson suggested. And also, as this court has said, the interest in the even-handed application of circuit law, the idea that the circuit would issue a precedent and it would be binding on everyone except the state, and that the state could take it to the Supreme Court and say that it was a binding decision and that they wanted review of it. That just doesn't seem to be consistent with both the circuit precedent and law of the case principles that are underlying this court's decision.
Can I ask a slightly different question, and then I'll obviously yield to my colleague? Can you talk to me a little bit about whether we want to call it standing or mootness? It seems we've got a little bit of a situation where the court, the district court, and frankly this panel accepted the client's representation in July of 2018 that she had a present and imminent intention to return to Planned Parenthood, having just been there in July of 18. And at least as of August of 18, she was able to do so. And then for what appears to be more than 2 years before COVID kicks in, she doesn't go to Planned Parenthood at all. And then COVID kicks in, and maybe that provides some excuse, but then COVID, goes on for quite some time. And in March of 2021, they raise mootness as a concern. And then only in July of 2021 does she say, oh, okay, now 3 years later, I still have this intention to go do this, and you should believe me, because even though I didn't act on that intention in the last 3 years, I'm really going to do it now. How do we square that with this idea in cases like Lujan and our cases applying it, that someday intentions aren't sufficient without concrete plans? I mean, why do we think, looking back at this now, with the benefit of the information that we've got, say that, we all, including this court, did not look hard enough at that initial allegation of intention. And it turns out, we now know based on her actions, that she did not have a concrete plan to go back to Planned Parenthood. And that in fact, all she did was indicate someday intentions to get around to maybe sometime when she felt like it, going to Planned Parenthood. And that's just not enough under Lujan. Can you respond to help me understand why I should read it any other way?
Sure. I think that as the court recognized last time around, Ms. Edwards' need for contraception, long-acting contraception, is not a someday intention in light of her significant underlying conditions that would make a pregnancy potentially deadly to her. And that's something that was in the original declaration that she filed and that this court discussed the last time around, that she has a number of underlying conditions and acute medical needs that resulted in an acute need for this contraception. And that's why she went to Planned Parenthood in the first place. The state hasn't provided any evidence to suggest that anything has changed. But in order to put the matter to rest, we submitted a declaration from Ms. Edwards that indicates that she intends to continue receiving medical care from Planned Parenthood. There's no question that medical care related to that contraception is covered by Medicaid. She also explained why she hasn't gone to as many medical appointments during the pandemic because of her underlying.
No, but she doesn't explain at all what she did from August of 2018 until March of 20, right? I mean, she says, oh, well, once COVID hit, I didn't want to go to the doctor, right? But she alleges, it turns out, we now know falsely, whether she knew it was false at the time is a different question, but that she was going to go to Planned Parenthood for annual wellness checkups, right? So she was there in July of 18, July of 19 comes around, she doesn't go. December of 19 comes around, she doesn't go. January of 20 comes around, she doesn't go. Maybe we say in February of 20 or February or March of 20, the pandemic hits, right? But she didn't go in the almost 2 years where she said she was going to be, she alleged she's going to do annual wellness checks. And we now know that is false.
She also explained in her declaration the last time around that she has.
Do you agree it's false? Maybe start with that. Do you agree that it is false? When she said, I have an intention to get an annual wellness check, that statement in the complaint was false?
No, because it stated her intention at the time. And I think that intention changed with the pandemic and the other circumstances of her life. I think in the declaration that she originally submitted, she explained that she has a number of medical conditions that mean that she has a lot of doctors that she sees on a regular basis and that sometimes she needs to triage them. I think the thing that we're talking about
here, she hadn't been to any doctors. Her claim is she doesn't go to any doctors now. This strikes me as precisely the sort of someday I intend to do something that Lujan tells us doesn't work.
I think it's substantially different from Lujan because the need for medical care is something that can safely be assumed and understood that a person has in their life, particularly when they have significant underlying conditions, like the court addressed last time around that Ms. Edwards has. We cited, for example, the Harris decision from the Ninth Circuit, which states that common sense proposition that people need medical care in their lifetimes. And the declaration that Ms. Edwards submitted indicates her continuing plan to seek that care from Planned Parenthood. And I guess I would say that the state hasn't done anything to question the veracity of those declarations. It never has. And so it hasn't come to this court with any kind of evidence, sworn declarations, nothing. It's just a suggestion in the reply brief that it could have raised any time. So we don't think that there's a mootness question here. If Your Honor does, we would respectfully submit that the right thing to do, if you thought there was a serious question, would be to return this case to the district court for fact finding. This court doesn't normally find facts like this in the first instance, especially when there's no factual submissions from the state. So I appreciate your questions, and I appreciate the court's probing of this issue and to make sure that there is still a live dispute. But, this is nothing like, I hope to visit a national park in the future. This is a person who has had a hard time receiving medical care. And the panel recognized that last time around, that Medicaid patients are some of the most vulnerable folks, and that there are a lot of providers, particularly in the state, that are not willing to treat them. And that when she found a place where she could get the care that she needed, and the state said that it was going to cut off that care, that was really an acute injury to her. And so to suggest that that's not an injury that could be remedied by this court's decision, I don't think respectfully that that's correct.
Let me ask you this, and after 2018, did she see any other medical care providers?
I don't know that the declaration speaks to that exact question. I think she talked about what happened during the COVID pandemic and the fact that she said she significantly scaled back her visits to doctors. She said that she did have visits to specialists who had treated her type 1 diabetes and related complications. So I think the supplemental declaration, fairly read, does suggest that she had medical providers that she needed to see during that time. But she also indicated that she was trying to manage her need to receive care with some of the risks that she faced because of the pandemic.
Well, I mean, of course, there are many instances where someone doesn't just, I don't know that there's any instance that she saw other medical providers, but even if she did, all of us go to multiple doctors for one reason or another. There are very few people who just see one doctor. You see one doctor for one purpose, and you see another doctor for another purpose. And what she's been seeing Planned Parenthood for has been a prenatal care, which they specialize in, with physical exams, vaccinations, and counseling and the like. I can't help but feeling that we're trying to make everything, going to extraordinary lengths to make everything about abortion one way or another. And I deeply respect the pro-life perspective as a very humane perspective, but this has never struck me as a case about abortion. It has struck me as a case where the intent of Congress to provide the less fortunate citizens among us adequate medical care. And that seems to me apart from the question of abortion, because if a Planned Parenthood clinic is in the business of providing abortions, it would be subject to a fund cutoff. And I just don't see this. I realize that we're trying to make this and that and everything about abortion, but I don't see it as a question about abortion. I see it as what Congress has provided, a right to Medicaid recipients who are in less fortunate circumstances than many of us are. I can choose my doctor. I can choose my healthcare provider, but many people can't. And Congress has sought to give those people a right of choice, not on matters of childbearing or abortion, but a right of choice in terms of seeking the provider that they believe will help them the most, and to put the less fortunate among us on a more equal plane to the most fortunate, who all of us, maybe or many of us, have nice health insurance plans, and we have the choice of the best medical providers and the rest, and Congress has sought to even those scales. And that's kind of the way I looked at it. I mean, I looked at it that way before, and I haven't changed my mind one whit. But would you care to comment on that?
Sure. We think the court is exactly right. This case has nothing to do with abortion. The district court made a factual finding that no state money will be spent on abortion as a result of anything that happens in this case. And there's particular care that Ms. Edwards sought because she has some pretty difficult underlying conditions with diabetes, and Planned Parenthood was willing to give her that care, and she was happy with the way that she was treated. And we think that this court really did a careful and thorough job the last time around in considering this question. The Supreme Court has said, don't go around implying private rights of action in federal statutes willy-nilly. You got to look to make sure the statute is unambiguous and look at our precedents. And that's exactly what this court did in a really thorough opinion. And we appreciate the fact that the court recognized that, not every statute can have a private right of action, but the court said that this statute was unambiguous and unmistakably clear. And
one thing that concerns me is that there's statements made in the brief that just do not accurately, in appellant's brief, that do not accurately reflect what this court did. And they said, you didn't discuss the Gonzaga case at all. We did discuss the Gonzaga case, and we said that a private cause of action is not generally implied, but that it was clear here under Gonzaga. We did address that case frontally, and yet we are told by appellant somehow that we did not. And that I find troubling to say the least.
Right. I mean, the arguments that the state is pressing now are arguments that the court considered last time around. And, whether it's law of the circuit, which is just binding, or law of the case is nowhere near as flexible as the state is suggesting. In order to come to a new conclusion, the court would have to find that the decision was so wrong that it stinks like a 5-week-old unrefrigerated dead fish. And that's just not a fair suggestion or representation about the court's very thorough decision, which just faithfully did consider the Supreme Court's precedents. Everything that the Fifth Circuit considered in terms of Supreme Court precedents, this court considered last time around. And so we don't think there's just any reason to revisit that decision. I'm happy to answer any further questions if the court has them, but it seems that perhaps there are not any. So I would just urge this court to affirm. Thank you.
Judge Wynn, do you have any questions?
I do not, Judge.
Judge Richardson, do you have some questions?
Nothing further.
All right, Mr. Birch.
Thank you, Judge Wilkinson. I want to start with Judge Richardson's comment, which I think is exactly right. When you're talking about the same case and a subsequent appeal with the same panel, it's akin to rehearing. And I now want to make the case to you why you should rehear this case. The U.S. Supreme Court's decision in O'Bannon
Let me ask you something. Let me ask this question. Do you think it was required that this case come back to this panel?
I don't know the circuit assignment rules well enough to be able to answer that question, Judge Wynn. If we were in front of a different... You seem
to assume that a panel once constituted keeps the same case even after we remanded for either a preliminary injunction or whatever, and it comes back. You seem to assume, what if one of us took senior status or retired, or one of us decided we were going to do something else and someone else sat in our stead? It would be a different panel. Would it be the law of the case then?
Then it would be the law of the circuit. different panel in the same case.
So let me make sure. You're saying it is only because the 3 judge as constituted remain on the same panel that is the law of the case. But if one of us was not on this panel and another judge was up here, it would not be the law of the case.
Well, let me be precise about this.
Let me hear the answer to that question. Is that true or not?
This court has not definitively answered that question. The best authority that I have.
I want you to answer it in light of what you're arguing here today. Is that what
Judge
you are
Wynn,
saying?
I'm trying to answer it. That
John, Mr. Birch, I want you to answer my question. And it's a very simple question. It's not a tricky question at all as to what you contend is, what constitutes this panel. And I'm saying these are the same 3 judges that sent it back and it came back. I first asked, you think that was required? And you say you didn't know, and I accept that. And then I said, well, what if one judge was not on this panel and you had 2, or 2 judges were not on this panel and you had it and it came back to it? Would that be the law of the case? In other words, is that a panel that is bound by law of the case?
Judge Wynn, it's not clear. This court hasn't said. The best authority that I have is Cooper's Federal Practice and Procedure. We cite this on page 9 of our reply brief, footnote 4, and it says that even in that instance, law of the case rather than law of the circuit would still apply.
So let me follow up then. So it doesn't have to be the 3 judges here. It just has to come back to a panel. It's not the constitution of the panel, it's the fact that it comes back to a panel. Is that
well, as I said, this circuit has not addressed the context where you have different panel, same case.
I think it's an important question. I think it's an important question because for what you're arguing. What you're arguing is that law of case exists in this case, and I'm trying to determine what makes it what makes it the law of the case. Is it the fact that it is the very same panel, and it didn't necessarily have to be this panel, just happened to be this one, or the court could decide, okay, it's by judicial efficiency, we'll do it that way. I think that's the way it's done. It's just maybe just an efficiency thing, but not required. So another panel totally different from this could have heard it, or constituted with any 1 or 2 of us could have decided. And my question is, with those permutations, which one of those qualifies as a panel for which this would constitute law of the case?
Under the best authority that either party has cited, it's law of the case as long as it's the same case on a subsequent appeal. But the easy instance is when you have circumstances like these, where you do have an identical panel.
But the same case in a subsequent appeal before what? Before a different panel, or because what you just, if you're going to cut it off there, if you don't add the word panel into it, that seems to have some import in your argument.
Yes, different panel.
Back to the same panel. Okay, so if it's not the same panel, that is identical in every aspect, that is, one judge is different, then it's not law of the case under your argument. Is that correct?
Under federal practice and procedure, that the Cooper Treatise that I just cited, which is the best authority that either side has cited, even if it's a different panel in the same case, law of the case is still the applicable standard.
Mr. Birch, I must say, I've sat in on a lot of cases and I have not seen in some time as bald and frontal attempt as this one is to unwind circuit precedent in a way that could only be destabilizing. And we can dance the angels on the head of the pin all day long, but what is at bottom here is you don't like the opinion of the court. You want to you have a petition for rehearing. You've taken it up to the Supreme Court, but I haven't seen a case where somebody just refuses to accept circuit precedent, tries to unwind it, and do so in a way that would raise all kinds of questions about this and exceptions to that, and would send litigants into a sea of indeterminacy, being unable to decide what the law of the circuit is and what they can rely on. And what it all comes down at bottom. You don't like the case, you want to get rid of it, but you can't do it this way. And the damage that your view would inflict upon circuit precedent is rather significant. And it is not, this is a case where normally a federal panel would defer to the state's decision to disqualify a healthcare provider. And the fact that it's questioned here doesn't mean that a federal court would be any less deferential to the state's decision under a great variety of circumstances. But what you brought here was a case again involving the disqualification of this provider that had been in the business of providing prenatal care for many, many years without objection. And all of a sudden, it's disqualified. And there would have been there's been no medical challenge to the fact that this provider was able to perform the services that was requested of it. And it's just bald. And you want a provider disqualified in the face of this statute that has not been proven to be disqualified for the services that it has provided low-income people for many, many years. And you want to do that by destabilizing the precedent of this court. And that's part of the problem, part of it, that I have with your view.
Judge
Always
Wilkinson?
litigants the last word, so you have the last word here, sir.
Thank you. Your Honor, we're not trying to destabilize circuit precedent. If you read the Kaufman decision and you think that it's right, all I'm saying is you have the power to fix a mistake. If you think that Kaufman was wrong and you got it right first time, it's entirely within your power, obviously, to issue the same opinion. But as for the question of disqualification, there is a remedy when a provider is disqualified, and that's to go through the state administrative proceedings and then judicial review. The Medicaid Act says that, South Carolina law says that, South Carolina regulations say that. There is a remedy for disqualification, but it doesn't belong to Ms. Edwards. Thank
Counsel,
you.
Judge Wilkinson, with your indulgence, can I ask one final question?
Absolutely.
Thank you. Ms. Birch, I'm having a little trouble thinking about the mootness argument that you've raised.
Yes.
Because on the one hand, I find it somewhat compelling. On the other hand, it's obviously based on like no evidence at all, right? So you made a representation, and this is not in any way impugning you, obviously, but you made a representation that is inconsistent, I think, or undermines the alleged intent of the plaintiff. The problem is the plaintiff's intent are all in affidavits, and there's evidence of it, and we can rely on that evidence or not. We have a little hard time, I think, relying on your representation of Medicaid data that obviously non-public and sort of not something we could take judicial notice of for obvious reasons. And so what would you have us do given that sort of predicament?
Yeah, thanks for raising that, Judge Richardson. The way to think about this is that it's the plaintiff's burden of proof to demonstrate that they have continuing standing at every stage of the case. For there to be Article 3 jurisdiction, the plaintiff needs to prove standing not only at the outset, but all the right way through to final judgment. In her most recent supplemental declaration filed in December, Ms. Edwards still does not say that she's attended an appointment at Planned Parenthood South Atlantic since 2018, only that she contacted them in July to schedule one. And if she actually had attended a visit.
Let me follow up with Judge Richardson's question. Is one thing, it's really, I think you're correct, standing is required. But the question is, how do you come about it? And in this instance, it's fair to say she hasn't said she's been back there the whole bit, but what you did was you disclosed non-public information about her sensitive medical information. And you did it without even consulting the other side. And I don't know how far that goes because, I mean, how much more would you disclose? I mean, and it's coming from you. There's a way in which you get evidence and information to the court. That's somewhat troubling. You disclose this information. She hasn't gone back for 3 years without even checking with her. And this is fairly sensitive medical information that you're putting forth. It's one thing to say, well, she hasn't said she's gone back, or we don't know what her intentions are. And, she's going, as Judge Wilkinson's alluded, for this care and his health care that she's been going there. We cannot look at this in a vacuum. Everybody on this call, and I mean, that is something we know, COVID has devastated this country. There are people, this court itself, we haven't sat but one time in the last 2 years. Does that mean we're not constituted as a court that will do oral arguments over 2 years because we didn't do it? We certainly had the intention to do it every time it came around. We had the intention to do it in the future. We don't know if we'll sit. But this COVID virus has really changed the world. And I think that as we continue to look at this, it really comes down to this. You're just talking about poor people and people who cannot afford to do things. It's really all it's about. I don't care how you put it. People with money and means would not be in this court talking about Planned Parenthood, whether they wanted abortion or whether they wanted reproductive services or not. And it seems as though these efforts are really going after poor, underprivileged, those who don't have, the least of them, constantly looking at their records. Did you in fact go to this place? And if you didn't, and we showed the Medicaid payments and stuff, you didn't go. And we put it out in the public, just like that. You think that's good policy, or even the correct way things should proceed here?
Well, Judge Wynn, it is not the state's intent to persecute anybody, no matter their economic means. They're trying to enforce state law, which says that no state money.
I'm not speaking to the intent. I'm not impugning your intent and what you're doing. You're doing your job, and I understand that. I understand that. I'm telling you what is happening as a matter of fact. That is what's going on here. We are dealing with poor, underprivileged people. And in this instance, you have a lady who it's difficult for her even to get services. You've got COVID all over the places. And she's trying to get the proper care. She's been everywhere she finally went to a place that treated her with respect. And she said, I want to use this place and it's my intention to go. But the government is there looking at her at every instance, not to help, not to help her get help, but to do everything you can to keep her from exercising this opportunity. And then you disclose it to the world. Well, we can show she hasn't even been there for the last 3 years or so without even asking or saying or checking her or finding a reason or anything. Does that sound like the right way to do this kind of thing?
Judge Wynn, 3 quick points in response to that. First, when Ms. Edwards received her Medicaid card, she also received a HIPAA disclosure that told her that her medical information could be used in a legal proceeding. And so there was nothing untoward about the state using that information. And it didn't disclose anything sensitive. It didn't say what treatments she had or what illnesses she had. It simply said she hasn't been there. The second point is that it's her duty to prove, as she alleged in her complaint, that she would attend her annual exam.
Just in waiving HIPAA rights, those who are poor and have no means, they don't have any rights to having the information.
That's not what I'm saying.
Sensitive. Well, that's what you're going with. You're going basically, she doesn't have any rights. She signed them away. So she's not like everybody else with money up there that can go places because, she's poor. She doesn't get to come and tell us we can't tell this information. You want to go further with this? We can continue the dialogue on it if you want to go further on it, because I think you're going somewhere with this, and it's interesting to me where you are moving.
Can I hear points 2 and 3, and then go back to this?
Thank you, Judge Richardson. The second point is that it's her burden of proof to show that she's satisfied the allegation in her complaint. And so it's not our burden to disprove it. She has to prove that she's continued to go for her well exams annually. The third point is, it's not that she doesn't have the right to go to Planned Parenthood. It's that she doesn't have the right to challenge a disqualification determination. Planned Parenthood had a real remedy with due process that it could have pursued in state court. In addition, it had a practical remedy. Planned Parenthood could choose to give up performing abortions. And if it did that, then it could accommodate Ms. Edwards and any other Medicaid patient in the state. But it's Planned Parenthood's choice to go ahead with abortion services that caused it to be disqualified. It was Planned Parenthood's choice not to avail itself of the administrative procedure that was made available.
So your contention, this case is all about abortions?
No, my contention is that Congress did not create a private right in 1396 AA 23A, but instead set up a scheme.
Which is a very question we've decided, but I do not want Judge Richardson's questions to be cut off in any way. And Judge,
I'm good. Thank you very much. I appreciate your allowing me to continue for a minute, but I'm fully satisfied, Judge. Thank you.
All right. Let me mention one thing to you, Mr. Birch, and that is the point has been brought up that, well, the last visit was in 2018 and she didn't come in 2019 or 2020. And the pandemic didn't hit until March or whatever of 2020. But there have been many, many times when I have not gone to a doctor for 2 or 3 years, irrespective of the pandemic, but I always wanted to know that that provider was there. Just to take the case of a colonoscopy, guidelines recommend that you receive one every 5 years under some circumstances, or more frequent, or 10 years under other circumstances. And many other specialists are like that. We don't consult them every year or every 2 years. But when circumstances arise and we need to consult them, it's important that they be there. And especially if we've had some experience with them. And although I might not need to talk to my eye doctor or my gastroenterologist or whatever for several years in the future, I would consider myself injured in fact if they were taken off an eligibility list. It's important that they be there when you need them, and it's important for Ms. Edwards for this to be there when she needs it. And there's one thing I would and it's more in the sense of a reflection than anything else, but I began this argument with a question about just how much I respect the underlying humanity of the pro-life point of view. And I'm very sympathetic to it. But wouldn't it be equally humane to just want the maximum chances to bring healthy babies and healthy children into this world and to take advantage of prenatal care that might be provided folks who sought not an abortion, but a healthy baby? That's what, as I can best tell, Ms. Edwards might one day want. And in the interim, she wants the care that it would provide. And so you have a very humane perspective in your views on abortion, but there's also another humane perspective that is at issue here. And that, as I've said, is the right of our less fortunate citizens to have some access to decent health care on the medical problems that mean most to them. And I don't understand why we are going to such lengths to close that off in the face of what I regard as Congress's contrary expression of intention. And that is just something maybe down the road that you want to think about, and that is that humanity lies in bringing healthy children into this world, and that's what Miss Edwards is trying to do. So, again, I give you the last word, sir.
Thank you. In closing, Judge Wilkinson, making sure that every baby is born and gets to experience life is precisely why South Carolina adopted the policy that resulted in the disqualification decision here. And if that disqualification decision was contrary to the will of Congress, Planned Parenthood had a remedy in the state administrative process and a judicial review of that administrative proceeding. It does not have a right to a federal court action. Thank you.
We're talking about not Planned Parenthood's right to a remedy, but we're talking about Miss Edwards' right to a remedy. But at any rate, I'm going to ask my co-panelists if they have further questions of you. Judge Richardson has no further questions. Judge Wynn, do you have further questions?
No further questions, Your Honor.
All right. I want to thank both of you very much for being here. We appreciate your argument so much. And we'll now move into our next case.
Thank you.
Versus Southern Farm Business Life, and Mr. Murphy. No, let's see who is arguing for Mr. Whitmore.
Hi, good morning, Judge.
Please
I
proceed.
begin?
Yeah, please proceed. Go ahead.
Thank you, Your Honor. May it please the court, my name is Joseph Matea, and I represent appellate Robert Whitmire. Words within a statute must be read and must be given their plain meaning. This has been the guiding principle within statutory interpretation law for North Carolina for over the last century. The district court violated this principle when it decided to interpret a North Carolina notice statute in a way that rendered parts of it meaningless and did not give all the words their plain meaning. Additionally, the district court failed its duty to adjudicate this matter in accordance with North Carolina law when it failed to apply these principles. As this court said in Suarez, any federal district court sitting in diversity of a legal state question is required to determine that based on how that state's Supreme Court would rule. This is first done by looking at the state Supreme Court's rulings and then to the opinions of lower courts. Looking at the law found throughout North Carolina's history, it shows that there are clear and four salient points about why the district court did not properly interpret the statute placed before it. To start, Your Honors, the Supreme Court in North Carolina on State v. Beck directly stated that when a statute is clear, plain, and unambiguous, there is no room for judicial interpretation. Rather, a judge has a duty to give those words their plain meaning. It is important to note that in the district court's entire opinion, it does not once state that the statute is ambiguous, confusing, or murky. In fact,
what if given it meaning would lead to an absurd result? What if you do that and you look at it and you say, that's absurd?
Yes, Your Honor. So there is a principle within North Carolina that states that if you read a statute plainly and it leads to an absurd result, that it is possible for a judge to change the way that statute is basically interpreted and written. However, that does not seem to be at all present here, given the facts known specifically to Ms. Whitmire's policy, as well as to the actions that Southern Farm itself took. Additionally, the district court itself referenced a case, Vodica v. Barlin, that talked about
Can you go back? Wait, can you go back? You just gave us two conclusions. Can you spill that out for us? Why is it that you think it's not absurd given the, I think what you're saying was the facts of this particular case?
Yes, Your Honor. So under this specific case, Ms. Whitmire took out a policy in North Carolina in 2005. For the next decade, Southern Farm sent every notice to that North Carolina address. And every time it sent that notice, it received a prompt payment and there was no miss of a premium notice being paid. As such, it's important to note that Southern Farm never spoke to Ms. Whitmire regarding a change in her address. As far as it was aware, the contract's address was always the same for the entire existence of the contract.
Counsel, let me ask you this. I'm just not sure that we need to look at the statute the way you do when you look at the words last known post office address in this state. I'm not sure that that's not free of some ambiguity. I'm not sure that it doesn't address the situation, that it leaves just, the statute leaves unaddressed the situation where somebody has left the state and gone to a different state. You say that the language is so clear, and if this were purely a plain language case, fine, I would agree. And I'm not much of a believer in the absurdity doctrine because I don't think legislatures are prone to do absurd things, and I worry about the absurdity doctrine leading us away from pure textualism. But when I kept reading the statute, it didn't seem to me all that clear, because I'm not sure that it addressed the situation of where the last address, the last post office address was somewhere other than North Carolina, and in this case, in South Carolina.
Yes, Your Honor, that is a good question. And there are two cases that provide great guidance in how we can look at these words and determine exactly how they are plain and unambiguous. The district court relied heavily on Napier when it came to its decision, which was a trial level court case out of New York that dealt with a notice statute that had those same exact words, last known post office address in this state. And that court found there was only one reasonable and logical way to interpret those words, which is the sending of a notice in the state where the statute was passed. Additionally, there is the case of Garland, which happened.
Well, of course, they did that. I mean, they sent it to dual addresses at one point.
Yeah, that is exactly correct, Your Honors. Is in June of 2016, when Southern Farm was informed by the USPS of an address change, it had no issue sending dual notices both to the North Carolina and the South Carolina address. And the crux of
it seemed to me that, you know, insurance companies are not always on good behavior, but, you know, just reading the total record in this case, I wondered if this insurance company hadn't been a model citizen and tried to do everything that could reasonably be done, because the whole purpose of the North Carolina statute is to increase communication between the insurer and the insured. And they went to some, I would be really pleased if all insurance companies went to the lengths that this one did. But there's another problem that I have with your position here, in addition to the ambiguity that I see in the statute. And that is that if we interpret the statute the way you want, I wonder if we're not interpreting it in a way that does damage to the sovereign interests of South Carolina, because comity as a principle of statutory interpretation must still be alive and well. And what you, because if she moves to South Carolina, North Carolina's interest recedes and South Carolina's interest begins to build. And I'm just worried about interpreting the statute of one state in a way that impinges in a rather basic fashion upon the citizens of another state. And we'd be telegraphing to the insurance company, hey, there's a way you can get out of this policy or whatever, and we don't want you to send this notice to the address that's most likely to reach the insured. Just go ahead and send it to a North Carolina address, and she'll maybe not receive it, and because she's in South Carolina, and then you can rescind the policy. And it leads to all kinds of problems to the disadvantage of the state to which the insured moves and takes up residence. I mean, somebody be in Wyoming and you just send it to North Carolina, and for whatever reason, it doesn't reach the Wyoming resident, and Wyoming's desire to protect the interest of its own citizens is shortchanged. That's the difficulty that I have. It's not a function of absurdity. It's a function of comity between different states, and a function also of the wording leaving some degree of ambiguity, and at least in my mind.
Well, Your Honor, there's a few points that I would like to respond to that I think can address your concerns. For one, your example of someone moving to Wyoming is completely free to pass any law that it would like to protect citizens that moved there, that took out policies in other states. So it is not on the burden of the North Carolina General Assembly to worry about the regulation of insurance in every other state in the country. Rather, it is worried about North Carolina contracts. And at the trial level, Southern Farm did try to get this case removed to South Carolina, trying to make the argument that it has an interest and that was the state where it had the most impact based on this case. And as the trial court ruled, and it agreed with Mr. Whitmire, is that a policy taken out in North Carolina for a North Carolina resident that has been paid in North Carolina for over a decade, that's governed by North Carolina law, that is the state that has the most interest. And the North Carolina General Assembly, by instituting this specific notice statute, was making clear it's worried about notices within its state. And
well, but the Wyoming example, the South Carolina example, I'm not sure why our federal system puts a burden on Wyoming or South Carolina to check the laws of every other single state to see if there might be some notice provision that disadvantages its own citizens. That putting a burden on South Carolina and a burden on Wyoming, that again strikes me as difficult to justify under a notion of comity.
No, that is a very good point, Your Honor. But at the same point, what you raise is putting a burden on North Carolina to protect citizens of every other state. The North Carolina General Assembly represents the constituents of North Carolina. As such, when it is passing a law, it's worrying about the people within its borders and contracts that are governed by its law, as well as the fact that Wyoming could very well easily make a law without looking at the other 50 states and simply say, if someone has an insurance policy that lives in this state, the insurance company must send them a notice. There's plenty of states in this union that have no notice statute at all. In fact, Southern Farm's headquartered out of Mississippi. There is no notice statute akin to this at all in the entire state of Mississippi. Southern Farm sells policies in Mississippi. I venture to guess they still send premium notices in those states because, like any service provider that is providing a service, it's going to send you a bill. But getting back to the crux of this case regarding the North Carolina law, an important principle is to understand that when there is a compulsory insurance statute, as here, the courts are required to interpret it liberally to extend coverage where reasonably possible. And there are several cases from Harrelson to also State Capital versus Nationwide that gives good examples of the Supreme Court of North Carolina just doing that. And What I submit to this court, Your Honors, is it takes no liberal or broad interpretation of the statute to extend coverage here. It requires the most straightforward and simple reading of the words.
Well, let me interject, and I'm following up. I've been pondering Judge Wilkinson's positions on it, which I respect highly in terms of where he's going, and I think we're headed in the same direction on this. I'm having trouble at least looking at this statute, even from a textualist position or plain language, finding ambiguity in it. It looks like to me this statute says just what it says. And I know Judge Wilson may not like the absurdity way. I tend to think that's the way you have to come out of this, because there's nothing in here that says that makes it ambiguous because you didn't consider that someone could move out of state. I think the North Carolina legislature probably considered that when they did this. They looked at it and says, you know, we got military bases here and people that travel all over the place, and we have major companies and people, even in my neighborhood, I know people moved 4 or 5 times, probably in the last few years and stuff. And so North Carolina looked at this thing and says, okay, if you're going to do business in this state, you need to send that notice to the last address in this state. And when I look at that way, it makes it simple. What makes it really troubling here is your client actually had the Postal Service to send a notice, because I think there's a temporary one and a permanent way you do it, and then they send notices to people that said it to this company and said her address is in South Carolina. Then that company, and Judge Wilson is right, I think this company went way out of his way to do all it could. It sent notices to them and said, okay, where you want us to send it to? As I understand, she never responded either way, one way or the other, on where to send those premium notices to. And the result is you got this conundrum here. The insurance company seems to have done everything it could, and even the husband here, who's who was actually paying the premiums on it, he knew he wasn't paying the premiums on it. I mean, that's the troubling thing. That doesn't have anything to do with the notice, but it drives to the fact that she's the one, even though she didn't do it directly, that got the postal people to send it to the insurance company to say she's out in South Carolina. And so when you have a person who sort of goes beyond the statute, says, okay, you don't need to send it to the last known address, send it to South Carolina. And then when they send it to South Carolina, says, oh no, and she passes away, you should have sent it to the last known address. Doesn't even mean, nobody could have been there. I mean, she didn't necessarily have to come back to that address. It may not even have been an address there. And what you're saying is, if the insurance company had done just what you said, and that is, she's in South Carolina, post office has already told them to send it to South Carolina, insurance company sends it to the last known address, would it be your position that that's okay, even though they have noticed that she's now in South Carolina? Would it be your position that's okay?
Well, Your Honor, I see that my time has expired. Can I have time to respond to that question?
Please,
yeah, absolutely.
Yes, Your Honor. I would say that underneath those circumstances given, yes, that's exactly where the notice would have to be sent, North Carolina, because again, this is not a question.
But that's not the only place the notice could be sent. It doesn't prohibit sending notice anywhere else. All it does is provide a default rule that says, whatever else you do, right? You have a customer, you need to provide for them. But what it says is, whatever else you do, like as Judge Wynn indicated, we're North Carolina, we're about protecting North Carolina people. And so whatever address you got in North Carolina, like this state, which I don't read to be anything other than North Carolina, you gotta at least send one to that state, right? That's all it says. It doesn't say you can't send it to any address you want to send it to. And in fact, as a good insurance company, maybe that would make a ton of sense. But the point is that whatever you do, there is a floor, and that floor is you must send it to the last address in this state, meaning the great state of North Carolina.
That is completely correct, Your Honor. It provides a safety net for North Carolinians because it's a North Carolina law. And as you're pointing out, the insurance company is only sending a notice to wherever it can, but it must send one to North Carolina for a North Carolina policy. And it's important to note, as already that's been noted by the panel, The Southern Farm already sent 2 notices back in June of 2016 to 2 different addresses. So it's not as if it's a crazy high bar for it to meet to send that additional notice. Additionally, it sounds as if the argument that the notice has to be sent to North Carolina is really just a problem with the wisdom of what North Carolina's General Assembly wanted to guide its insurance practices to be. And Your Honor, that is not an argument for the court of law here today. That's an argument for the North Carolina General Assembly. An argument was very similarly made and sent where the district court was faced with a similar issue where it seemed like sending the notice according to the statute would not make much sense. But as that court correctly noted, that's not the court's job to determine how North Carolina decides to make policies lapsed. The court's job is to read the words on the page and require compliance with this compulsory insurance statute. As such, Your Honors, I am submitting to this court today that this is the reason why the district court must be overturned and Mr. Whitmire's motion for summary judgment should be granted. I see my time's running out and I don't want to continue going on.
Thank you, Mr. Mattia.
Thank you, Your Honor.
Mr. Pullman.
Morning, Your Honor. Thank you. Aaron Pullman on behalf of Southern Farm Bureau Life Insurance Company. May it please the court. I'd like to start with a point that has not been addressed thus far, and it has to do with the argument that is actually presented by the appellant in this case. The appellant's argument, both in the district court and in this court, was that the statute at issue required Southern Farm Bureau to send a notice of lapse to Mrs. Whitmire, which is different from a premium notice. And in the district court, the plaintiff articulated this argument quite clearly, saying that there's a significant distinction between premium notices and lapse notices, and that only a lapse note, the statute only requires a lapse notice and does not apply to premium notices. So the issue that is presented by the plaintiff appellant in this case is quite narrow, actually. The issue is, did Southern Farm Bureau violate the statute when it sent a notice of lapse to Mrs. Whitmire at her South Carolina address in September of 2016? That is the issue that is actually presented by the appellant, even though there are a lot of other issues floating around here. But the answer to that question quite simply is no, because the statute itself does not apply.
I'm sorry, I don't understand that. Say that one more time. No, I don't think anybody's arguing that sending anything to South Carolina violates any statute. The insurance company is not prohibited from sending it to South Carolina, publishing it in a newspaper. I mean, this statute doesn't prohibit them from doing anything. It is not a ceiling, it is a floor, right? And so they can send anything to South Carolina they want to. All this says is, whatever else you do, you must also send a written or printed notice stating the amount of the premium to the last known address in this state.
I understand your point, Judge Richardson, and if you'll just indulge me for just a second. And I agree with the point you're making, except that the point I'm making is that the issue that's before the court has to do with the lapse notice versus premium notice, and whether the statute applies to lapse notices versus premium notices.
But you just said that they violated the statute by sending something to South Carolina. And what I'm saying is, maybe that's not what you're saying, or maybe I misheard you, but I thought you just said the question is whether they violated the statute by sending the September notice to South Carolina. And what I'm saying is I don't see how in the world that statement can be true.
It either requires, the statute either requires the notice to be sent, and if it requires the notice to be sent, then it's a violation of the statute if you don't send the notice.
Well, but it requires a notice to be sent to the North Carolina address. It doesn't prohibit sending any notice to the South Carolina address. The point is, you can send 2 notices, right? But the statute requires that you send at least one, a written or printed notice stating the amount, right? And all these other things to the last known address in the great state of North Carolina.
Understood, Your Honor. And I'm not disputing that point, but I think we're saying the same thing. That
all right. Well, help me understand then, because I maybe I've misunderstood.
Yes, sir. The statute requires a notice to be sent, and if the notice is not sent, then you have violated the statute.
The notice is not sent to the North Carolina address. Well, you can't cancel the policy, right? It doesn't mean the statute's been violated. It just says that you can't then cancel the policy.
Right, but it's still a violation of the statute. The statute actually has a requirement that the notice be sent, as you pointed out, to the last known address. The language says to the last known address in North Carolina, but it's
no, it doesn't say that, right? It says no policy shall be forfeited unless a notice is sent to the last address.
Yes,
so
sir.
you don't have to send the notice at all. You just got to keep the policy in effect.
I would still argue, Your Honor, that it's a violation of the statute if you don't comply with that notice requirement.
No, it's only a violation of the statute if you forfeit the policy having not sent the notice.
Well, the statute actually requires the policy to remain in effect for a year if there's no compliance with the statute. But
what about the bonus counsel? What about the point on this facts that, I mean, the Southern did send letters to both North Carolina and South Carolina addresses asking where they should send where they should send their communications, and Susan never responded to those. And then in addition, she filed a change of address form with the post office to the South Carolina address. The import of that is get in touch with me in South Carolina. And when you look at the bank statements and the auto insurance premiums and the driver's license and everything, and her filing the change of address with the post office to South Carolina, doesn't that, it's almost like it's a request to send communications to the South Carolina address.
That's correct, Your Honor. Mrs. Whitmire did file a permanent change of address notice with the U.S. Postal Service, which then Southern Farm Bureau became aware of. And so that's what prompted the two letters to be sent to confirm the change of address. So one letter was sent to the North Carolina address to confirm the change of address. The other was sent to the new South Carolina address to confirm the change of address. And when there was no response to either, the insurance company from that point forward assumed that her address was in South Carolina, which it was.
Why would it do that? It seems like the assumption would be the other way. You didn't get a confirmation that there was a change. But let me ask the other question. Judge Richardson has raised an interesting point, and I think it's going more to addressing the plain language of this statute, because we don't look at something being absurd if there is a reasonable way to look at it in terms of the plain meaning of what's here. It seems very clear to me this statute says what it says, last known post office address in the state. I think I'm still sympathetic to the cause that it sounds like that could create an absurd result. But Judge Richardson, I think, and Judge Richardson, correct me if I'm getting this wrong, is saying that's a flaw. That doesn't mean you can't do other stuff. But if you're going to do business in the state of North Carolina, you have to send a notice to the last known address in this state. She can say I'm in Wyoming. She can say I'm in South Carolina. I'm overseas. I'm everywhere else. And you may have to, she may have an argument that says, well, you need to send it there too, which that doesn't keep her from asserting that you should have sent it there too. But the state of North Carolina says, send it to the last known address in this state. And why is that not a reasonable interpretation? That's, and again, Judge Richardson, if I'm misstating your position on this, let me know, because that sounds like what he's saying. Because if you're looking at the plain meaning of statute, you really, in my opinion, got to struggle, and I yield, of course, to Judge Richardson a different interpretation, if he articulate again or whatever, to find that ambiguous. This thing says just what it says. And is troubling in terms of what's going on here, because it doesn't seem right to me. I think the insurance company may have done it all it could, but of course, the point you're making that she didn't confirm would seem, if she didn't confirm she's in South Carolina, seems like to me the reasonable person would, well, I'm gonna send it to where it's been, because no one's confirmed this. I got this from the post office. They make mistakes, they do it, but no one there has told me to do anything different. How do you respond to that?
Well, I think that the businesses around the country are allowed to rely on notices from the post office of a change of address. And if the insurance company receives a notice from the post office that there's a change, then they will. That is one of the policies that they have, that they will then continue. They will then send correspondence to the new address.
I grant that, and I don't disagree with that at all. I think that sounds good, but still, it doesn't get rid of the whole business that this statute just creates a floor.
Well,
doesn't mean so. So what that means is now you got to send one to South Carolina, but under this statute, you got to send one to North Carolina and South Carolina. The way I'm reading, if that's the case of it, if you want to be, compliant with the statute.
Right. Well, there are not many courts that have interpreted this language. There are none in North Carolina at all, except for this court. And the only courts that have looked at a substantially similar statute in New York, which was enacted many, many years ago. And the case that Mr. Mattia mentioned was Napier, which is a trial court level case in New York. And the ruling from that court was, there was a situation where the insured and policy owner was not in the state of New York. And so the question was, was the insurance company required to comply with the statute to send, what do you do when the insured is out of the state? They don't live in New York. And so the ultimate conclusion of that case was that the only reasonable and natural interpretation was that the requirements of the statute only applied when the policy owner was living in New York and not somewhere else. So I think this goes back to Judge Wilkinson's original point, which was
just to be clear there, like Napier said that like last known address in this state meant last address in North Carolina, right? I mean, it interpreted the language just like Judge Quinn and I have suggested, right? That it means the last post office address in North Carolina. Now, it may have had a different issue, but it interpreted that language contrary to how the district court did and contrary to how you did to mean what your opponent suggests, right? It means what it says.
I think that the New York court was saying if there's no last known address in this state, then the insurance company does not have to send any notice at all. It's not required to comply with the statute.
All right, so that makes perfect sense to me, right? Because if in fact there was no last known address in North Carolina, so if your insurance company never knew of a North Carolina address, I don't know how that would happen, but let's assume you didn't. Well, then if there is no last known address, then it's a null set and you wouldn't have to send anything to that address. All right, that's fine. That means the statute doesn't apply, but we have a last known address here.
It's our position that if an insured moves states, that this statute doesn't address that situation. That if there's a notice,
it plainly considers that somebody's moved, right? I mean, you will concede the statute considers that somebody might move, right?
It possibly does, but it doesn't actually address.
That's what last known address means, right? Is that suggests that somebody might not be at that address anymore, right?
Yes, sir. But I think
the statute plainly considers that there are other states in the union other than North Carolina, because it doesn't refer to, it doesn't just stop. It says this state, capital S, right?
Yes,
great state refers to itself as it should, right? It's this state. So it acknowledges that there are other states. I mean, I'm having a real hard time understanding how you're getting where you're going.
Well, I think the same reasoning applies whether the insured never had a residence in the state or moved states, because last known address in the state In other words, it doesn't apply to if the last known address is no longer in this state, the last known address is in another state, then the statute is inapplicable. The last known address is no longer in this state, it's somewhere else. The insurance company received notice.
No, but if somebody moves, so imagine the person that we're describing lives in North Carolina, and you know they're in North Carolina, and you got an address on Main Street. They then moved to South Carolina, and you know that, and then they moved to Wyoming, and you know that, right? The natural reading of the last known address in this state is the North Carolina address on Main Street. It's not the last known address in the abstract, which in my hypothetical would be South Carolina, right? It's the last known address in this state. No matter how many times you've moved since then, what's the last address you have in this state?
Understood, Your Honor. We take the position that that the way that the statute should be read is that last known address in this state is not applicable if the last known address is not in the state of North Carolina.
And you think that's a permissible reading of the statute?
Yes, sir. I think it's consistent with the way that the statute has been interpreted by the only courts to examine that language.
How do you get it out of this language? I don't know how you get it out of this language. It says his or her last known post office address in this state. But if I can also address briefly, Judge Wynn, your point about the absurdity doctrine. You know, if this is the reading of the statute, is that it requires the insurance company to continue to send premium notices indefinitely to an address that it knows to be incorrect. It creates all kinds of absurd problems for both the insurance company and the insurer. So, you know, according to this concept.
All right, so wait, why would it require to continue to send premium notices? All it would require is that before you forfeit a policy, you send a notice, one notice. You ain't got to send it every month. You ain't got to send it every quarter, right? All it requires is before you forfeit or lapse for non-payment, you must send a notice, one.
Your Honor, I think to be compliant with the statute, the insurance company would have to continue to send these notices every time a premium is due. That's what triggers. All right, help me
walk me through the text that would require that. Why would the statute? I mean, I don't see anything in the statute that requires that, so I'm having a little hard time.
Okay, you're right. It says that any corporation, insurance corporation doing business in the state, shall within 1 year after the default in payment of any premium cannot declare, forfeit, or lapse any policy issued or renewed, unless a written printed notice has been duly addressed and mailed to the person whose life is insured or to the assignee or owner of the policy at his or her last known post office address in this state.
So
what room in this?
As long as there's no default, you just keep going. I'm sorry, Judge Wilkinson. I didn't mean to interrupt you.
No, go ahead.
I'm good.
What part in this statute does does her actions play? Is there something akin to the invited error or wherever when somebody has everything else, the driver's license, back auto insurance, bank statements, and actually files an address, a change of address form. And is that tantamount to a request to the insurance company to say, here's my address, send your communications to me?
I think that the way that the insurance company, the policies of the internal policies of the insurance company work is that if it receives notice of a change of address from the U.S. Postal Service, that it will then, it went ahead and sent the confirmation letters. In fact, the confirmation letter to the old address said, if this is wrong, and that's a good point, I should have mentioned this earlier, the confirmation letter to the old address, North Carolina address, that if we received this notice of your change of address, if this is incorrect, please notify us that this is incorrect. and there was no notification forthcoming. And in fact, she had moved to South Carolina. So that was a confirmation to request, as you're saying, Judge Wilkinson, that we need some kind of confirmation from you if this is incorrect. And so the internal policy of the company is we've received notice. They're entitled to rely on that, and they ask for confirmation, for the insured to let us know if this is not the case, and that's why they sent it to the old address. And they didn't receive any notice that it was incorrect. And in fact, she had moved to.
Well, all I'm saying is that I haven't seen a lot of cases in which an insurance company actually bent over backwards to this extent to find out how it could best communicate with the insured.
Yes, sir. Well, their position is that they did do that, that they made a good faith effort to determine where the notification should be sent. And in fact, it turned out that was correct. She was in South Carolina, and they sent all of the subsequent correspondence to the correct address.
And how much correspondence was sent to her correct address?
Well, there was the next premium notice was sent, which was in November of 2016. There was a lapse notice that was sent in December of 2016 when the premium wasn't paid. There was a subsequent letter in January 2017 about the lapse and inviting her to reapply for coverage. So there were at least 3 letters that went after the 2 letters that were sent to confirm the change of address.
I mean, I would be delighted if I had an insurance company that made those kinds of extraordinary efforts to keep in touch with me.
Yes, sir. And if I could just
Judge Wilkinson, you should try to cancel a subscription to a magazine. They're gonna send you 3 or 4 letters.
If you all indulge me, I see that my time is up. If I could just have a few more minutes to talk about the absurdity doctrine. And I don't want to do that without permission. So if someone will allow me to, I will.
All right, thank you, sir. We appreciate it. Mr. Mattia?
Yes, Your Honor. I just have a few quick points that I wanted to respond to in kind based on the panel's questions as well as Southern Farms' positions. One, there's been a lot of discussion regarding about Ms. Whitmire taking actions and instituting changes when she moved to South Carolina. From my knowledge and from my research, I have found nowhere in North Carolina law that Ms. Whitmire's actions alone can change that an insurance company has to follow the regulations set down by the North Carolina General Assembly. As it's been pointing out by Judge Richardson, this statute provides a safety net. It provides a basement of what must be done. And Ms. Whitmire taking actions to move herself, to change banks or whatever else, does not change that Southern Farm is required as an insurance company operating in North Carolina to follow North Carolina law.
That doesn't sound quite right, that there's nothing an insured can do here with regard to this. It seemed to me there's probably some things could be done. She could acknowledge or submit some sort of consent that the last known address for this purposes of the state of North Carolina, she'll be in South Carolina. I mean, she probably could do that directly. I would be sensitive to that even though, because here, the purpose isn't so much to send it to the address, it's to get it to her. That's the purpose of it, and that's what you're really going to it. But when you get into purpose, the question is, are we back into ambiguity of the statute here? But this strict requirement, I have no doubt that your opponent is correct, will create serious problems for insurance companies. It is inartfully drawn. I don't know how many other states have it. I've sat on the Uniform Law Commission for well over 25 years myself. I don't know if I've seen too many like this, but you may need to get some lobbyists to go back to North Carolina and clean this statute up, even if you prevail or not prevail on the other side of this case. But, you know, I don't get it in terms of where we are with regard to this language and whether it's absurd. And I'm leaning to say maybe there is a reasonable interpretation that would say it's not absurd. And I don't think I don't know where my colleagues are on absurd. I'm having some trouble with this ambiguity though. This statute says what it says. I don't like what it says, and I don't like how it plays out here. And she did do it. There's the problem here that I see. The insurance company, I think, correctly says you could probably rely upon a change of address notice from the post office. I mean, probably could. But they sent confirmation notices. They didn't just rely on it and got nothing. And it would seem to me if you get nothing, you just keep doing what you've been doing. You wouldn't assume this. But I could see both sides of it. How do you come out on that? Well, I know how you come out on it. Go ahead. Just give me comments.
No. Yeah, I understand, Your Honor. And I think you make a good point, though, in the sense that there is a track history here of what happened underneath this policy for a decade. And for a decade, Southern Farms sent a notice to a North Carolina address. And for a decade, it collected over $20,000 in premiums from the payments on those notices. And what's important to note is that it had an entire contract set up understanding this woman, Miss Whitmire, lived in North Carolina. As such, it was required to follow North Carolina law. And what is insightful from dealing with this is that there are principles within North Carolina from the Supreme Court directly from it relating to forfeitures, how they are not favored, as well as a compulsory insurance statute must be interpreted in a manner that gives coverage where reasonably possible. And as my time's winding down,
you know what makes this really troubling is that it was Mr. Whitmire was paying these premiums. He knew that his wife was not paying these premiums at all. He had no indication she paid a premium at all. He knew he hadn't been paying these premiums, and maybe the notices were going or not. I'm only saying that not in terms of interpretation of the statute, but when we get into the business of the parties and who's blameworthy and who's not, I mean, he's not totally innocent on this thing here. He knows he's not being paying premiums. You don't pay premiums, policies lapse, but you got to have the right notice for it when it lapses. That's the problem we got, and that's where we get to the statute here on it. And anyway, I don't know how we'll come down on this. At least I don't know how I'll come down on it, but it's an interesting case.
Well, Your Honor, I think you make a really good point, though, in the sense that Miss Whitmire left the residence in North Carolina before the May notice of 2017 was sent there. And when Mr. Whitmire received that notice, he paid it, even though Miss Whitmire was not currently at the residence. So it's safe to assume that if he would receive that same exact notice 6 months later, in accordance with the semi-annual billing of the policy, that he would have also made that payment, showing that Southern Farms compliance with sending a notice to the last known address would have kept this policy in effect. And I see my time winding down here.
Can I ask one question? Maybe I just got confused on that. So the May notice went to North Carolina and got paid. Where did they send the November notice to?
They sent that to South Carolina, where it was not paid, Your Honor.
Not North Carolina.
That is correct. It was not sent in the state of North Carolina.
And so the blame, if any, on Mr. Whitmire is that he didn't notice that the bill he'd gotten for a decade didn't show up. And so he didn't then raise the alarm that he should keep paying the premium that he had been paying for a decade.
Well, yes, Your Honor, being that it was direct billed, every time the bill would come in, like any sort of bill you have, like a water bill, you pay it once it arrives at your house. And it did not arrive during this time of November, so he did not make a payment as he did for the 10 years prior. And lastly, if I can conclude, there is a case in North Carolina that shows how this statute was interpreted by a North Carolina court and how it's found to be implemented. And that case specifically, Your Honors, is Garland. Now, there's been some contention by the district court as well as Southern Farm about the precedent of what Garland gives us. However, it's the only case in all of North Carolina that gives us direct insight to how a judge dealt with this statute. As such, I would find that it has very high precedential value to understanding how this would play out. And specifically in Garland, we get the jury instruction from the court that shows if it is found the notice was not sent in this state, you must find as a matter of law, the policy could not have lapsed because, again, the statute was not complied with.
I have one last question. If Judge Richardson, did he completely answer your question on that?
Absolutely.
So I have one last question. She sent a change of address notice, which meant that if mail went to this last known address, it would go to South Carolina. Is that correct? In other words, if they sent a notice to that address based upon a change of address, then the post office would forward it to South Carolina. That is correct, right?
If I don't have the notice in front of me if it was automatically forwarding, but I know she did update her address underneath the post service, but I do know that sometimes it does not automatically forward all your mail there.
Well, I think if we followed it, the post office is going to do what it says it do, and you ask them to forward mail to address in this state to another place. The question that I'm having is, was that still in effect when she was back at this, when she died? Was that still in effect, the forwarding of the mail to the South Carolina address? And you see where I could go with that, and that is, it wouldn't make a difference to send it to the North Carolina address, because it's like having a triangle, or point A to point B. You don't have to go to point B if point B is going to send it to C. From A can go straight to C on it here. So was that, does the record disclose, is what I should ask, that forwarding process was still in place when she died?
As far as I'm aware, she did not send an updated change of address form to the USPS. And I think that can answer your question, Your Honor, in the sense that the record doesn't reflect anything regarding that change. And if I may just wrap up, Mr. Whitmire's.
Yeah, just to make sure I understand though, but there's I don't know the answer to this, but the post office doesn't forward your mail, forever, right? And so even if there's a request to forward, and I don't know that we have one here, do we know how long it lasts?
In terms of the length, I believe you can set the length when you send the post office your change of address. But I
do we
think
have any of that? Is any of that information in the record? I guess.
Yes, I believe that it is. I believe it's typically done for, I think, 365 days. I believe is the standard. I think I'm not 100% sure, as I don't have the notice in front of me, Your Honor.
Okay, but you said that's in the joint appendix.
Yes, that is correct. In the sense that you will find it in there, the change of address that she filed. And in wrapping up, Your Honors, Mr. Whitmire's entire argument simply has been that Southern Farm was required to do what it did just 3 months before sending this notice, which is send a notice to a North Carolina address that it did for Ms. Whitmire when it was notified of that address change. And if it would have done so, it would have been entitled to forfeit Ms. Whitmire's policy for a missing premium payment. Since that was not followed by the plain statutory language required, Ms. Whitmire's coverage was still in effect when she passed away just a few months after that missed premium payment. Thank you, Your Honors.
We thank you, and we will proceed directly into our last case. Thank you both.
Thank you, Your Honor.
That will be me, Danielle Fewer, for Appellant Ronnie Kuhn.
Okay, we're pleased to hear from you.
Good morning, Your Honors. Good morning, Your Honors, and may it please the court. The only question before this court is whether there's at least a genuine dispute of material fact on Rodney Kuhn's ADA and RA claims, such that they should have survived summary judgment. The answer is a simple yes. In fact, Mr. Kuhn brings quintessential reasonable accommodation claims, sitting at the very heart of the ADA and RA. Mr. Kuhn has a severe mobility impairment, walks with a cane, and has a medical no climbing restriction, so he couldn't safely climb the 2 flights of stairs to the prison library. He didn't ask for much, just a pass that would allow him into the already operational handicap library, so that he could access library services with safety and dignity, notwithstanding his disability. But he was denied even that basic accommodation over and over again by decision makers who didn't so much as consult him or muster the effort to check whether he had any restrictions, which of course he did. These facts undeniably lay the foundation for claims under the ADA and RA, and they also present a clear picture of deliberate indifference, an issue that the district court did not even reach, because it remarkably dispensed of his claims on an erroneous reading of the basic elements of these statutes alone. The district court's key errors were twofold. First, the district court overlooked the reasonable accommodation right altogether, instead viewing these statutes as far narrower prohibitions on animus-laden conduct. And second, the district court blurred the lines between a non-cognizable medical malpractice claim on the one hand, and on the other, a cognizable reasonable accommodation claim that incidentally touches on the decisions of medical professionals. This court should reverse the faulty decision below, reinstate Mr. Kuhn's ADA and RA claims, and remand for further proceedings. The district court took its first wrong turn in the very framing of Mr. Kuhn's claims. Mr. Kuhn brings a classic reasonable accommodation claim, but the court overlooked that right altogether. Just as important as the negative obligation not to engage in overt discrimination is the affirmative duty on public entities to provide disabled individuals with reasonable accommodations so that they can enjoy public programs and services just like their able-bodied peers.
Why do you think the accommodation was denied here?
Your Honor, the accommodation was denied here because Mr. Kuhn submitted repeated sick call requests to receive a handicap pass, and Defendant Browning denied that handicap pass request. Mr. Kuhn then submitted an administrative grievance, and it was denied at step 1. It was denied at step 2.
This is a misunderstanding over the question of whether this is a renewal or not.
Your Honor, we do not believe that this boils down to whether there was some sort of misunderstanding about whether this was a renewal request. First, it's important to point out that during—
I thought that was the reason that she didn't give that, because she thought it was a request for a renewal when it actually was not.
Ms. Browning does state in her declaration that that is how she understood the request. However, we'll note that each of the 3 sick call requests that Mr. Kuhn made, which do appear in the record, request a handicap pass outright as opposed to a renewal. In addition, there's a dispute within defendant's own evidence in that during the grievance process, Defendant Wells, as well as the other agents of NCDPS, stated that the handicap pass, the accommodation being requested here, was denied because it was not medically necessary. We'll also note—
let's take your view that it was a mistake here. The difficulty I'm having is whether this rises to the level of deliberate indifference. Whereas, normally there has to be with the deliberate indifference standard, you have an objective standard and you have a subjective standard. And the objective standard is that of a serious medical need. And then the subjective standard requires a mentally culpable state of mind. And then I suppose if the delay or in getting the pass, because he did eventually get the pass after 6 months or so, has to result in some kind of serious injury. And I'm wondering whether any injury that occurred was as a result of the prison authorities, or whether it was a result of the injury, whether it was the result of an automobile accident in which he was driving with a cocaine high, and he was in a crash that killed 2 parents and a young child. And to the degree that there's an injury, I'm not sure why the injury was a result of any kind of action on the part of the prison authorities, as opposed to a pre-existing injury, a pre-existing problem. There may have been a mix-up here. I'm just The only question I have is whether on this record it rises to the level of deliberate indifference, which is maybe there's a higher standard than that for the abrogation of sovereign immunity. The courts are split over that question. But let's take your view that it's deliberate indifference. I just don't know how the facts here rise to that level.
Your Honor, I'll briefly clear up the last part of your question, which was concerning Mr. Kuhn's injury. He did, in fact, suffer a meniscal tear subsequent to his efforts to access the library services, notwithstanding his disability. It's in the record that he had to hop up the stairs one at a time in contravention of his direct no climbing restriction that the prison system itself recognized in order to access that library. And in doing so, he did incur additional injuries. Of course, exacerbation of an injury that's pre-existing does still constitute an injury. And within the context of the ADA and the RA, almost everyone who's covered by these statutes is going to have some sort of pre-existing impairment. But to touch on your overarching question, I would respectfully submit that the deliberate indifference standard is in fact different here. What Your Honor was reciting is the deliberate indifference standard that applies for an Eighth Amendment claim, which of course is tied to the Eighth Amendment's guarantee against cruel and unusual punishment. And because of that, the deliberate indifference standard for an Eighth Amendment claim is tied to the serious medical needs of the prisoner and so forth. Here, the deliberate indifference standard is a general matter. The first step is...
Well, but the deliberate indifference standard is one that has been adopted for ADA claims as well, hasn't it? I mean, you yourself began your argument by saying this is the question here is whether there was deliberate indifference.
Yes, Your Honor.
Correcting that, and what I'm wondering is, why does the deliberate indifference standard change from one context to another? Why you say, well, deliberate indifference means one thing in the context of the Eighth Amendment and another in context of the ADA. And I'm not, it's the same language, it's the same term. I'm not sure why it would change.
Your Honor, the two steps of the deliberate indifference inquiry are one, that there's knowledge that harm to a federally protected right is substantially likely, and two, the failure to act upon that likelihood. That first step, harm to a federally protected right, is what is malleable depending on the underlying inquiry. Here, the federally protected right at issue is the reasonable accommodation claim, is the reasonable accommodation right, apologies, under the ADA and the RA.
Why is that any more important than an Eighth Amendment right?
It is not, Your Honor. Mr.
You
Kuhn,
seem to suggest that it was.
No, Mr. Kuhn brought two claims below. We have only appealed one of the summary judgment determination on one of them. Below, he brought a 1983 claim that inherently wrapped in the Eighth Amendment and its prohibition on cruel and unusual punishment. Deliberate indifference with respect to that distinct claim would import the standard that Your Honor has described concerning the serious medical need of the prisoner and so forth. That claim is not before the court today.
I'm wondering, we're going to have a hierarchy of deliberate indifference sort of tests for prisons.
There is not a hierarchy of deliberate indifference tests. Rather, the deliberate indifference test is specific to the underlying right being asserted. Here, Mr. Kuhn asserts that there was deliberate indifference with respect to his reasonable accommodation right under the ADA and RA. And it is that right that is fundamentally at issue here. There's not so much a hierarchy.
Let me ask, just for clarification, when we're talking reasonable accommodation, typically a discriminatory animus is not necessary. But in the context here, you're asking for compensatory damages. And so that imports the deliberate indifference standard. And if I'm understanding the Eighth Amendment standard, which I suppose you could have brought an Eighth Amendment claim too, here for the injury here that you allege. If I understand, the harm is somewhat different than the Eighth Amendment because it has to be substantial. Whereas in this instance, everybody's kind of already agreed that the knowledge of the harm is a federally protected right is substantially likely, and that the failure to act is a likelihood is the basis for it. So when we're looking here, we look more to the actual facts to determine if there was a deliberate indifference, and this again is for the purpose of the compensatory damages, because I think if all you want is just a reasonable accommodation, I don't know if you need to show that. If reasonable accommodation, you show there are certain factors you show, that wheelchair ramp or whatever has to be built. And you're not looking for compensatory damages, but your client is looking for compensatory damages. And that's a whole different question as to what in the world would that be. And you asked for $200,000, but I just don't know what that would be in a prison context. And that may well be a short answer to all of this as to what in the world does he want, in a prison context. You can win a case, and ultimately at the end of the day, you wonder, well, what are you going to do? And maybe there is that pie in the sky that you can get some huge damages here, but I don't know. But I think in terms of the deliberate indifference standards, Judge Wilkinson's question goes to, is it different from the Eighth Amendment? Is it different from other things? And why is it different in this context? And maybe I'm not getting clear on your answer on that.
Thank you, Your Honor. Yes, there are a few different ideas at play in your question. First, I will note, of course, before this court is not the question of ultimately what level of damages Mr. Kuhn would receive, or even whether he would ultimately prevail before the finder of fact. The question really is only whether Mr. Kuhn should be entitled to the opportunity to present his claim before the fact finder, given that it was prematurely tossed out by the district court. And I'll note that
do we have an abrogation of the state's sovereign immunity here? Is brought against North Carolina?
Yes, Your Honor. There is abrogation of the state's sovereign immunity. The sovereign immunity inquiry is twofold here. The easiest question for this court is whether the state has waived sovereign immunity under the RA by its acceptance of federal funds. And every state, including North Carolina, accepts federal funds for its prison. In fact, defendants
wouldn't, if you want to go that rate, I'm not sure that you raised it, but wouldn't you have a Pennhurst problem in terms of whether the state was on notice that accepting federal funds made it liable for claims of this order of magnitude? What I'm concerned about are damage claims because somebody was assigned to the wrong dining hall, or somebody was given the wrong diet, or somebody was put in the wrong cell. And just as a Pennhurst matter, it seems to me that states are being hit with a lot of suits that they didn't receive notice of in accepting federal funds. And then when one goes over to the ADA, I'm wondering whether, if the ADA covers every small decision adverse to an inmate, I'm wondering whether that makes the state liable for compensatory damages for a multitude of small decisions. Whether that really is congruent and proportional. Because Section 5 of the 14th Amendment requires congruence and proportionality in order for state sovereign immunity to be abrogated. And I wonder if you take the claims and bring them down to this very small, minute level and say, oh, well, that abrogates state sovereign immunity, then I'm wondering how that's congruent and proportional.
To start with your question of the Rehabilitation Act, this court has held that the acceptance of federal funds in
Did you ever raise that before district court?
Yes, Your Honor. Mr. Kuhn did raise sovereign immunity under the waiver of the sovereign immunity under the Rehabilitation Act below. I am looking at district court docket number 61 at page 9. And there, Mr. Kuhn does say that defendant's action waived the 11th Amendment immunity, including under Section 504 by its receipt of federal funds. And he, in so doing, does cite an appropriate authority. Therefore, of course, Mr. Kuhn was proceeding pro se below, so he is entitled to a somewhat broader reading.
So by accepting federal funds, the state is agreeing to supervision at this minute level. Would the state have been on notice that it was putting itself in for all of that?
Yes, the state is on notice, and it's well established in this court that a state waives sovereign immunity under the RA by its acceptance of federal funds. This was made unambiguously clear in the 2005 Constantine case, which of course is well before any of the violations Mr. Kuhn alleges here. And we would respectfully submit that that is firmly rooted in this circuit's precedent. To turn to Your Honor's second question with respect to sovereign.
You've got some rebuttal time.
Yes, Your Honor.
I'm going to ask if any of my co-panelists have questions for you at this point.
No.
Judge Richardson. All right, thank you.
Thank you.
Mr. Williams, would you unmute yourself and we'll hear from you.
Thank you, Your Honor, and good morning. May it please the court, my name is Alex Williams and I'm representing the defendants in this case. This case is very simple and it can be resolved without having to ever get to the issues of sovereign immunity. As Your Honor touched on, this is a case that involves where the plaintiff is requesting money damages. And
let me ask you about the sovereign immunity in terms of how it's postured before us. Did the district court actually rule on that? Did it delve into it to any great degree?
No, Your Honor, it did not.
So even if we went there, it would be something that would probably be appropriate if we're going to deal with the 11th Amendment type questions, send it back for the district court to flesh it out. But insofar as the sovereign immunity, the other question I have is, I know you brought up it with regard to the ADA in your brief, but you don't seem to even mention sovereign immunity for the Rehabilitation Act. So doesn't it appear to me you waived the sovereign immunity for the Rehabilitation Act? Was that what you intended, or but it looks like what you did? Because I don't see it in your brief unless you can show it to me.
No, Your Honor, there are a couple different things regarding that. Number one, I would say that I still don't believe that plaintiff ever asserted a Rehabilitation Act claim. It's nowhere mentioned in his complaint. He never mentions Rehabilitation Act. He never mentions RA. He never mentioned Section 504. He doesn't do any of that. And while I understand that the courts are liberally construed pro se complaint, we have a very unique situation here where a plaintiff filed a complaint. The court.
Well, the problem is the district court actually construed this complaint to allege a rehabilitation claim. And I'm just asking in terms of your brief here. And, you know, I fundamentally believe if we delve into the sovereign immunity, it's probably something the district court should flesh out first, if we go there. And you started out saying we didn't need to do that, so I'll just let you proceed in the manner you were going.
One question to follow up on what Judge Wynn said. You've suggested that the most direct way to this, without maybe the need for a remand or for wrestling with these Pennhurst and proportionality questions and congruence questions, is to say, look, it's conceded that the standard is deliberate indifference, and that's not met on these facts as alleged. And then your opposing counsel says, well, that's an issue of triable fact. And your view is, no, the grant of summary judgment was perfectly fine on this record. And I wonder if you would expound on that a little bit, because that's what I find what you say appealing. The questions involving the Pennhurst questions involving the Rehabilitation Act claim and the congruence and proportionality claim questions surrounding the abrogation of sovereign immunity claim are quite intricate and difficult, but you're saying we don't have to reach that because everyone agrees that deliberate indifference is a permissible standard. It might even be higher than that. Some courts have suggested that, but I wonder if you could respond to what your opposing counsel said.
Yes, Your Honor, and I think Your Honor is correct. We don't need to get to those other issues that are much more intricate, because we can just rule on whether plaintiff has satisfied his obligation to obtain monetary damages. And when we start talking about this, the first case really hit on it was a U.S. court case that was Guardians Association versus Civil Service Commission of New York City. And they actually required, and I know that case has dissents and concurring opinions, and it's a little bit of a mess, but that case actually stated that it would require a discriminatory intent. And since then, other courts have tried to determine, okay, what did the Supreme Court mean by that? A lot of courts have settled on the deliberate indifference standard. Plaintiff seems to.
Well, that's another thing. If we had to be thrust into the middle of a debate about whether the deliberate indifference standard is the controlling standard or whether the discriminatory intent standard, there's a huge circuit split on that question. And, all of these things are lurking in the background. The Pennhurst question, the congruence and proportionality question, the question of whether deliberate indifference or intentional discrimination is the standard. But everybody has said it is at least a standard of deliberate indifference.
That's correct, Your Honor. And I think that even if you say it's at least deliberate indifference, our courts have routinely said that is a lofty bar for a plaintiff to meet. Our courts have said that they have interpreted that very highly, and they have required that there be actual notice that their actions will harm the plaintiff. And they have also.
I think I agree with Judge Wilkerson in the way he's postulated this case, that, there are a lot of complex issues here on sovereign immunity, and there's some splits, but we all agree on the deliberate indifference. And I think so we get into the question of, this is a summary judgment, is there a triable fact that's presented? And what seems to present a question here to me, and it is, articulate to me, how is it that the government was not aware of the problem here? I mean, he alerted the Department of Public Safety about his status and the no climbing restriction, his need for accommodation. He mentioned these issues to his sick call requests and to prison officials directly and during the informal grievance process. And then They had medical records on him and his ADA designation. And I'm not saying that's the only evidence there, but I'm dealing with the triable fact issue on it. And so why is that not at least sufficient enough to create a triable fact? You may well could win beyond that, but at least in terms of where we are, the procedural place where we are, why is that not a triable fact, enough to create triable facts for the court to move forward on?
Your Honor, what I would say is that when you look at these deliberate different standards and these cases that interpret it, when you see that there was an evaluation and you see that there is the officials are responding to the individual, they will say that that is not deliberate indifference. They are trying to answer the defendant. They're trying to work, plaintiff. They're trying to work with the plaintiff. They're trying to work with him and respond to his concern. That's what happened here. Yes, he did submit the call request. They did. I
think your interpretation and where you're going is a reasonable way of going it. But I read through this, and it looks like to me there's another side of this question. I mean, they never did really medically evaluate him, and Browning never did. And there's a question: was her evaluation a medical one, or was it based on the fact of not being a renewal of it? And I'm just saying it just looks to me like there's some questions here. I'm not saying which way it goes, but we're in summary judgment, and summary judgment means summary judgment in a light most favorable to the non-moving party, not in a light most favorable to the prison side or to the way the court feels like it should be. And so when you get to that, the question is summary judgment. That's all I'm going on. I'm not trying to make a judgment one way or the other, which way it goes. I accept every point you make. The points on the other side is what I want you to address to let me know why that does not create a travel.
Well, Mr. Williams, let me just say one thing, that before we go into sending this case to trial, we would have to, on deliberate indifference, we would have to answer the threshold questions of whether there's been an abrogation of sovereign immunity and of whether this passes muster under whether the state has a Pennhurst claim. We can't just send this to trial without asking the threshold question, which sovereign immunity is, of whether there is an abrogation. I would think that sending it to trial assumes that, yes, if you put the state to trial, we would have to assume that there's been an abrogation of sovereign immunity and that the state is liable for these kind of claims, of multitudinous claims, detailed claims of prison administration, and it was provided notice under Pennhurst of that. And those are preliminary questions. Those are threshold questions. If we hold that this is an issue of triable fact under a deliberate indifference standard.
Judge Wilkinson, yes, you and I agree. You and I agree on what you just said. And the only reason I posed those questions that way was because he put it in a position that even without getting to that, it could be resolved. And so I agree. If we do find there is a triable fact, those are threshold issues that have to be decided. But I also think that the government didn't even address two of those three city of Bourne factors that's even there on this whole sovereign immunity question. And most sovereign immunity questions, when you're going dealing with 11 amendment, you at least let the trial court flesh out the facts and what's going on here. So if we do it, then everything's pointing to a remand on that. But I don't disagree with you, Judge Wilkinson. I want to make that clear. I don't want to look like you and I were in conflict in terms of how we're looking at it. I only jumped there because of the way it was postulated at the beginning here that, ultimately it can be decided on. And I'm saying no. I think that looks like a trial fact. So that's why I want to put it in that posture with you.
Let me just say to my good friend in response that I would agree with you on the issue of triable fact if the standard here was negligence. But the point the Supreme Court makes over and over and over again is that deliberate indifference is a pretty high bar. And you have to have an objectively serious injury, and you have to have a subjectively culpable intent, and you have to have the causation in the sense that delay caused the injury and all of that. And they say this is a very high bar. It is not just it's not just a negligence standard. If it were just a negligence standard, I think your view would be compelling. But the standard of review here, I mean, the standard of culpability, in light of all the Supreme Court has said, Justice Marshall wrote the seminal opinion in the Estelle v. Gamble case. And if you want some strong language about the fact that deliberate indifference cases are supposed to be the rare exception and not the general rule, the Estelle v. Gamble case sets it out with unmistakable clarity. That's where if we have a difference. I'm not saying the prison administration was perfect here. It just seems human beings make mistakes and they're misunderstanding things. But that's, to me, it comes down to the difference between deliberate indifference and negligence, which I think the court has stressed time and time again. That seems to me where it goes. But
I want to again agree with you, Judge Wilkerson, because we now bounce from the threshold issue back to the different indifference. I'm okay with that. That's where and so now to address whether there's a triable issue of fact, I do point to the fact that the parties have agreed what it is. I mean, there are a lot of other factors we might want, but parties have agreed what deliberate that it exists if the government first has knowledge that a harm to a federally protected right is substantially likely, and two, that it fails to act upon that likelihood. That's the agreement of the parties here. And, of course, we determine the law and everything. That's the whole question. But then it gets to the question of what is a triable fact. And I laid out those facts to counsel saying, okay, I accept everything you say. That sounds real good in the light most favorable to you. But this is a summary judgment in the light most favorable to the defendant here, or to the complaining party, the plaintiff. And when you look at those facts, does it create a triable fact? That's my question. But I agree with the posture you put it in, Judge Wilkerson. First, if we deal with it, if before you send it back, yeah, you ought to send it back and say there's some threshold issues to deal with it. If we move away from that and get to the actual issue here that they all say is deliberate indifference, could be a difference of opinion, should it be more, whatever, but that if we're going to say that we agree, then we look at what they say it takes to exist, then do those facts create tribal issues of fact? Maybe that's too simplistic in the way I've looked at it, but that's, maybe you can help to make it a little bit more complicated from the counsel side.
Mr. Williams, I think you should be back in the action. We kind of, Judge Wynn and I had a nice discussion, but I'm afraid
we agreed for the most part, Judge, in terms of at least the posture of the case, so that's the good news.
I love my discussions with Judge Wynn, but I feel like, and I think it's all my fault, and I feel like I've cut you out of the action. So please proceed.
Well, Your Honors, I think you both hit the nail on the head, and that is that this case doesn't have to deal with all those other issues if you find that plaintiff did not satisfy a deliberate indifference standard. And Judge Wynn, to answer your question about how plaintiff did not meet that standard, plaintiff did not meet that standard because in this case, the defendants did respond to plaintiff's concerns. Now, they might have made mistakes in responding to plaintiff's concerns, but they weren't just deliberately indifferent to his concerns. They did respond to his concerns. So in this case, when you look at it, you see that Browning, she did get these sick call requests and she did respond to them. She did look at his medical records. Now, did she overlook some things? Yes. Did she make mistakes? Yes. We can't change that. But that is at best negligence. It does not rise to the lofty level of deliberate indifference.
And he did,
on multiple occasions, they denied him his rights, and that caused him some harm. I mean, he's he's pretty severely injured, and I will concede to anyone that facts of how he became injured are just egregious and tragic, just terrible. But he's an injured person there, and to go up those flights of stairs, I mean, it's very graphic in terms of what's going on here. So they denied him those rights. And I mean, it's not like they kept responding and says, we're doing the best we can. And I'm not saying they didn't respond. I'm just saying there's evidence on the other side of it, tribal issue of fact.
But I think the evidence on the other side does not rise to the level of deliberate indifference. At best, it rises to the level of negligence. And
he got the permit.
Yes. And so now the question is,
he was able to go to a library. He had to climb some stairs. In other words, but the point is, human beings, prison officials, anybody, we're not perfect. We all make mistakes. But I would hate to think that every mistake I have made, and there have been plenty of them, they're not mistakes of the heart. They're not deliberate indifference to somebody. I just made a mistake. And that's where the law of negligence comes in, is that, negligence is supposed to cover snafus and mistakes and misunderstandings and that kind of thing. But as I said, if I were going to be accused of deliberate indifference for every mistake I've made, I would be in litigation from now until the 22nd century. That's all I'm saying.
Yes,
in the context of answering that question, I agree with Judge Wilkerson. I think it is a higher standard of negligence, but it certainly isn't intentional conduct. And this was 7 months. This wasn't a couple of weeks, 7 months. And he is dealing with severe pain. He may be torn his meniscus trying to go up down those stairs. I'm just saying there's an issue of fact, and may not be, I don't know what you got to get to deliberate indifference, but if you don't, he doesn't have a choice. You do realize that, don't you? He's in a prison, and there's nothing he can do. So if anything, you would think in that context, the government has a greater, because everything is controlled with him there. And 7 months, and every time, and he's making every effort to try to get it. He's asking for it over and over. He's been declared it over and over, and he's being denied. And I'm not saying it should go one way or the other. I keep saying tribal issue of fact. It's not so clear cut to me that this is they just kind of did the best they could, and they were helping him and responded to him every chance, and then ultimately they gave it to him 7 months later. That's a long time for someone in a severely disabled situation to try to have reasonable accommodation rights afforded to him.
Your Honor, if I could, I know my time's about to expire, but if I could dovetail off that for 2 points.
We gave your opponent some extra time. Go ahead.
Thank you, Your Honor. The one thing I would say about that is I heard you say that he kept trying, and he was trying everything he could. After he filed his grievance and after the step 1 response, he was told the way to go about this. That was to submit this IRAR form, and he never did that. That was something that he never did. So I did want to make sure that the court was clear about that. The other thing that I will say is I heard Your Honor say this was 7 months. And what we have here is, again, it's just a delay. This was not an outright denial. He did get his handicap pass. And so the cases that I cited in my brief were a little bit shorter of the delay, and they stood the proposition that the delay is not a violation of the DA. So after plaintiff's counsel responded back that these were short delays, I started researching, well, are there cases with longer delay? And I was able to find 2 of them. One of them is in, it's not a direct prison contact, but it is another ADA case where an individual is denied an accommodation for a sit-to-stand death and was denied that for 10 to 13 months, depending on which fact pattern you believed. And in that South Carolina case, the court said that's not enough of it. That's not enough. It's not an outright denial. It's just a delay. It's a reasonable delay. And they cited to a Seventh Circuit opinion from 2000 that had a 20-month delay of a
Well,
job.
not only is there a subjective component to these deliberate indifference claims, there have to be a mentally culpable state, but there's an objective component, and that is there has to be a serious medical need, and the delay, such as it is, has to result in the serious medical need. When the question whether it's a serious medical need, but at any rate, whatever it was created not by the prison authorities, but it was created by this terrible accident when someone on a cocaine binge runs into a young couple and their child and kills all three of them. And you say, well, that's not relevant. But it is relevant because that's the genesis of the injury. That's the problem, not the negligence of officials. But at any rate, I'm going to say if Judge Wynn or Judge Richardson has further questions, we can do that. Otherwise, anybody have any further questions, or can we just go to Ms. Fuhrer? Counsel, you have some rebuttal time. We'd like to hear from you in rebuttal. Thank you, Mr. Williams.
Thank you, Your Honors.
Go ahead.
Thank you, Your Honors. I'd like to begin where this court has been focusing, which is with deliberate indifference. First, I would like to reiterate that the standard is distinct for a violation of the Eighth Amendment, as was brought with Mr. Kuhn's 1983 claim that, again, is not before this court on appeal, and a violation of the ADA and the RA, which are fundamentally different statutes.
If you would focus on what we've just discussed, and as I understand it, and while I do agree with Judge Wilkerson about the tragic nature of how he got injured, I don't think it's relevant how he got injured. It's that he is injured. He's just disabled like anybody else. Doesn't matter how he got disabled. He's just disabled. But if we want to import those things in, that's personal feelings, and I got that. But the question here is, we, as your co-counsel, seems to cabinet, we've seen the cabinets to a question of whether there is a triable issue of fact on the question of deliberate indifference. Your co-counsel has articulated that there was response. You heard him. There was response that this was not an act in which they did anything that was, unduly delayed, and on and on. So from that perspective, what do you say in the light most favorable here, because that's a summary judgment standard we're dealing with to determine whether it's a triable issue, are those facts that would create a triable issue of fact on the question of deliberate indifference?
On the first element of deliberate indifference, knowledge that harm to a federally protected right is substantially likely. Mr. Kuhn repeatedly alerted the prison to his need for an accommodation. He submitted 3 sick call requests to obtain a handicap pass, and he filed a grievance, again seeking a pass, when his request was denied. He could scarcely have been clearer about his need for an accommodation, and in fact, the risks to his federally protected rights themselves. In his first sick call request, which is at JA 45, in his sick call request, he identified himself as an ADA inmate, stated that he, quote, had to use a cane for a walking aid.
Let me ask you this, counsel. How far does this extend? Because you can make a request, and a great many inmates consider themselves ADA inmates. But you can make a great many requests and say, I didn't get the prison cell I wanted, and that exacerbated a bronchial condition I have, or I didn't get assigned to the dining hall I wanted, or I didn't get the food I wanted, and I'm an ADA inmate, and my request was denied. And a lot of those requests are denied, and a lot of those requests are repeatedly denied because in the final analysis, to say that every request from an ADA inmate has to be repeated requests, of which there are many, has to be granted, or you're going to be on the hotspot for deliberate indifference. That not only waters down the deliberate indifference standards, but it brings into play a host of Pennhurst and sovereign immunity abrogation questions and proportionality and congruence questions to let this case go forward. It may seem like just a small matter, but allowing it to go forward would have large consequences, including just sort of skating over the surface of really very difficult questions of sovereign immunity abrogation and the like. That's the problem.
Your Honor, I see that my time has expired. May I respond to your question?
Oh, sure.
Thank you. Our position certainly is not that any request or any series of repeated requests categorically needs to be granted in order to avoid a finding of deliberate indifference. Here, the critical facts are that Ms. Browning received this request. She did not so much as check to see whether Mr. Kuhn had any limitations. Mr. Kuhn was an ADA inmate classified by the prison system itself. NCDPS's own records said that he had a no climbing restriction, which is antithetical to having to climb the steps to get to the handicap library, to the regular library. And that unto itself meant that he needed access to the handicap library.
She's under misapprehension as to whether this is a renewable question, or whether this is a renewal question, or whether this is ab initio or what have you. That's the thing. I mean, human beings are simply not infallible. They just aren't. That's why we have the doctrine of negligence. We don't let them off the hook, but at the same time, before we apply one of these higher standards, we realize that there's really a difference. At any rate, we've been over this ground.
Can I follow up, Judge, with just two sort of, I hope, very narrow questions?
But may I ask for permission to have her to answer my question? She never really did get to my question initially, but if Judge Richardson wants to do so, and then she can answer my question, is fine. But I asked the question and I never got an answer to it. But go ahead. You go ahead.
Either way, it's fine. I just had two questions. I don't care when they get answered. Doesn't matter to me.
I'm the same way. We got plenty of time on it, but I would like to have the answer articulated on the record, because it is one that I think is focal to the question. I mean, we can talk sovereign immunity, we can talk tribal issues, we can go into other facts, but we had cabined this thing to talk about deliberate indifference, and then in my mind, that's sovereign immunity and a summary judgment. And the question is whether there's a tribal fact. And I asked the question, what are those tribal facts from her perspective? I heard it from Mr. Williams, and I think he articulated his side very well, his facts, and I simply want to hear the facts on the other side in trying to make a decision as to whether there's a tribal issue of fact for purposes of summary judgment. The other issues, they do exist, and I've agreed with Judge Wilkerson, they do exist, but if I'm at that point, that's the world we're in right now with that question. And would you mind answering that question, completing your answer on that question?
Thank you, Your Honor. There was ample information at NCDPS's disposal that reinforced Mr. Kuhn's need for reasonable accommodation. Of course, as we've mentioned, Ms. Browning did not so much as look into the database that's accessible within the prison that lists inmates' limitations. Mr. Kuhn had a no climbing restriction in the prison's records that Ms. Browning concedes she did not know about at the time, and therefore did not even try to inquire into. she conducted only a exceedingly minimal evaluation of Mr. Kuhn's medical needs. And this is a man who she says she's familiar with, who walks around the prison with a cane, and who is an ADA designated inmate and has repeatedly explained his need for a handicap pass. And yet there was hardly a perfunctory inquiry into Mr. Kuhn's serious limitations and the needs that made his request for a handicap pass beyond reasonable and appropriate under the situation. Then in turn, Mr. Wells, in his review of Mr. Kuhn's grievance, and note in Mr. Kuhn's grievance, he specifically said this library is located up 2 flights of stairs. He said he was being kept from enjoying the same privileges as other regular population inmates. He recounted his unsuccessful efforts to obtain a handicap pass, and he specifically cited his limitations and ADA status. And yet Mr. Wells did it seems nothing except for rubber stamp Ms. Browning's determination. He considered Ms. Browning's determination to be one that the accommodation was not medically necessary, when that is in fact contrary to Ms. Browning's own narrative, and suggests that he did not conduct even the barest of inquiries into Mr. Kuhn's needs. And the case law is clear, particularly from the other circuits, that can help guide us in this deliberate indifference.
Since we've gotten to case law, have we gotten enough there, Judge Wynn? I assume the case law is not what you're looking for.
Please proceed, Judge Richardson, with your questions. Thank you very much for your answer.
So
thank you.
You reference here and in a number of other places that the prison's own records indicated that he could have no climbing, or other places you refer to as a climbing restriction. Where can you point to me in the JA where that evidence is in the record? Because when I looked, and I could concede I'm not, I don't have a categorical background, but that seems to be denied, at least at some level, at JA 159. And I'm not sure where that is in the record.
Yes, Your Honor. If you would look at JA 43, that is the evaluation that was performed of Mr. Kuhn in response to his initial request to be designated as an ADA inmate. You'll see in section B, substantial limits in one or more major life activities, a check mark next to the word climbing, and then the word none thereafter. And he was at this point designated by the prison itself to be an ADA appropriate inmate who has, quote, considerable severity of limitations. And I believe—
Right, so that's I'm following you. So then the follow-up that is there record evidence? I just want to make sure I understand the record, right? So is there record evidence as to why he either did not request or was not granted a handicap pass initially? This is related to the renewal point. Do we have information that he requested and was denied, or what the reason he did not have a handicap pass initially was?
Mr. Kuhn did not have a history of handicap pass at his prior institution. Mr. Kuhn was not always at Pender Correctional Institution, which is an institution that has a general population library located up 2 flights of stairs, and therefore was inaccessible to someone with limitations such as his. He previously was housed at Lanesboro Correctional Institution, and in that institution, all of the facilities were located at ground level, and therefore Mr. Kuhn did not need to seek a handicap pass in order to have access to the library.
So that last point is what I'm looking for in the record, that Lanesboro, that there were no handicap passes, or he was not entitled to one because everything was on the first floor.
So he did not, to be clear, he did not seek a handicap pass because it was not necessary under the circumstances. And that is at JA 88, where Mr. Kuhn—
That's all I need. I don't need to read it to me. I'm literally just asking for the JA sites. I'm not—
Yes.
I can read them. Thank you.
Any further questions, Judge Wynn? Do you have any
I
further
do not,
questions?
Judge Wilkinson. Thank you.
Judge Richardson, do you have further questions?
No, thank you.
Okay. All right, we thank you very much, and we will,
Your Honor, may I respond to Judge Richardson's questions about the JA?
only if Judge Richardson wants you to respond.
I don't need those responses. Thank you very much, Judge.
Okay, no, you may not, because Judge Richardson has not asked for your response. All right, we will adjourn court until this afternoon. And we want to thank you both for your arguments. We appreciate them very much.
Thank you, Judge.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.